The signed matter is an appeal from degree original side and assigned matter to minor for inclusion.
Original side Are you mentioning about notice?
Well, I said so. I've informed them over the phone.
When was it assigned?
It has been assigned in the year 2024. December.
Suddenly what happened? You were sleeping for 2
We
years.
were not known, Maran. We have given letters for continuous assignment.
That is because
yesterday we have come to know that it has been assigned.
You were not diligent. You should have gone and anyway give this tip. Let us see how we can afford it. Yes.
I'm mentioning upon notice.
New motion, it automatically comes.
My lord, it's not in the list.
Appeal of which year?
This year. 2026.
When did you file?
March.
March you filed. When was the returnable date?
That's good.
Yes.
My lord, may I come to an application for inclusion?
New application.
New application.
New. It has never appeared. Give a hand over this thing. New applications, hand over this thing. New.
I have minor kindly mention an application. It's a section 5 application for combination of
In connection with a new appeal, or it was immediately
24 January 23rd by his lordship as there was. Third, at that point of time, it was a direction of his lordship to take appropriate steps, not because section 5 application for combination of delay was not referred. So
yes, you know. Are you mentioning about notice?
Notice after that, here have get one section 5 and stay.
Very good. Have you given? You have served. You know. আপনার অ্যাডভোকেট কে? চিফ সাহেবের ঘরে আপনি অ্যাপিয়ার করেছেন? অপরপক্ষ কে আপনার? অপরপক্ষ কে? কেউ ছিল না?
না, উনিও আপনার ঘরে পাঠিয়েছেন।
হয়েছে কিনা দেখে নেওয়া।
কেস নাম্বার হচ্ছে 300।
আরে অ্যাসাইনমেন্ট হয়েছে আপনি জানলেন কি করে?
আমি ছিলাম।
সেটা তো কোর্টে বলেছে। তারপর ফর্মাল অর্ডার হয়েছে।
হ্যাঁ, অর্ডার আপনার ঘরে পাঠিয়েছে।
চেক
Item number 1.
Short possible.
Yes, next. Oh, yes, madam. Yes. We didn't take up, you were not there yesterday. So we dispose of this stay application, we direct them to file paper books. The interim order will continue till the
But the conceptual level matter, where when the no action has been taken by the page according, administrative action should not be. And you will also in the earlier.
No, we passed an interim order. We passed an interim order. If you are agreed by this, you can come with appropriate application.
Submission made. And 7 days we proceed the affidavit and incorporate that. The other side will incorporate the affidavits. Okay.
Opposition here, you have to give the opposition. State has any role to play? Union of India. Then they have filed opposition. They have not filed opposition. Get to the outlet.
They will be in opposition. I don't, we have.
To the Union of India to exchange affidavits with Mr. Chatterjee, and we have directed him to appear after 4 days. Next.
Item number 3.
Yeah, that's it.
Two.
My other friend will come, I'm serving here. Called me over the phone. I say I do there with you, I'm not taking.
So you have not seen, you were there in the report.
I won't tell them.
That is, Dekhi, what is the matter? We may dismiss the appeal also.
That DA examination where the lordship permitted to sit, some persons, other case manner, they obtained the order. That they, diploma holders should be allowed to participate.
Because special indicators, initially your lordship said allowed only who have come 10 times. Then one last batch your lordships allowed, but they had come shortly after the last time. So he had accepted judgment. Relying on that judgment, I had submitted at that point of time that it would open the floodgate.
It should open the front.
Now
It should open because you have
Now
open a portal
but
and allow some
Aha, Mr. Hot.
person to apply.
You have not read the brief. What you have submitted?
She can come back.
now bunches of candidates are coming. I have filed two appeals on that. Whereby
Commission should not be afraid of the volume of the unemployed persons. The commission should be dissolved.
Now that counseling process is over.
Nothing has been done.
Well,
Written examination has
special
been done.
special educators for the post of assistant teachers. Oh, that special educator.
Yes.
Oh, acha, acha.
following the lordship order, we comply. Then they did petition. They were pure fencers. They came after such a long time. They were at least 6 months. But the learned single judge, because your lordship's order was there, has passed.
But Dr. Patro, Supreme Court has said that there will be special educators in. It is now a amalgamated
Yes,
scheme.
that is why this.
There are plenty of vacancies. So why don't you allow?
Firstly, the number of vacancies is not that much.
You serve come after 1 week. Next Thursday.
Yes.
I can change it.
3 and 4 next Thursday. করে দিই।
Yeah.
Got affidavits were there. You have corrected the other defects.
Yes.
Read petition number you are not mentioned. Eh? Not mentioned in the
79 days.
Opposing. The opposing section 5.
we dealt with a similar pattern. No? So we allow the section 5. You go through it, Mr. Lady. Come back to us.
District is different, post not. Post like total rate.
What's involved here? The cutoff marks is essential for computer tests. And second is that the observation has to be applied to each of the
We dealt with it.
come back. Okay, come back.
Allow. To argue that point, go through the order. Pardon? Before that, it won't be possible. My brother won't be here. He would be in this country. Yes.
I certain you can change the time of the matter.
What is changed?
That after the declaration
You are a learned advocate. How does it matter if you are out of the panel?
matter was decided by the lordship, so I want to explain the final lordship.
That is your hope. That is your hope. We may take a different stand. We don't know. Yes, next.
Take a lighter morning.
Yes. We panel and naam chuli gabe sejono.
My lord, in item number 6, I appear for the Madrasa Service Commission.
Yes. Hey, why you are in online position today?
My lord, I had some personal difficulty. That's the reason.
What is the problem? You whatever oppositions and everything.
No, my
completed?
opposition is ready, my lord. I would be filing. They have not yet filed the reply.
Mr. Dhol, learned advocate, appearing for the appellant's file.
No, I'm not for the
Oh.
appellant. I'm for the respondent commission.
You have filed the opposition.
Yes, my lord.
The learned advocate appearing for the respondent numbers 3, 4, and 5 files the affidavit in opposition. Let the same be kept on record. The learned advocate appearing for the appellants. Praise for extension of time. Got the copy? Praise for extension of time to file the affidavit in reply. In view thereof, such period is considered allowed. Let such affidavit in reply be filed within 2 weeks. 2 weeks. List the matter for further consideration. 4 weeks hence.
Obliged.
ওনার অ্যাপিয়ারেন্সটা দিয়ে দিও ওনার অনলাইনে। Yes,
Obliged.
next. What is the matter?
When I was studying teacher, appointed in the year 2016, and thereafter he participated in the 25 okay.
So you are untainted.
They can't take it.
Uh.
And but my lord, now the post is my lord abolished. My lord, 100-point booster and my post is abolished, my lord, now.
You are in which category?
My lord, assistant teacher of home science. But that post is abolished by my lord. My lord, 100-point roster introduced by the notification of labor department. My lord, now, my lord, my commitment.
So post of assistant teacher in home science have been left out
My,
from the advertisement itself.
my lord, subsequently, not as well,
Oh,
subsequently.
in advertisement there was post was
Participated in the existing examination.
very good. Then when did it change?
The vacancy, the first tentative vacancy, thereafter final vacancy that my lord, that post is
So in tentative vacancy it was there.
tentative vacancy not there. Also, but my commitment before you are not in,
But tentative vacancy is prior to the personality.
because they are after the examination. My lord, my commitment before you are not in, my lord, on 26 November 2025, the Honorable Supreme Court specifically stated that the untainted teacher who are appointed in the 2016 not no way affected by 2025 rule. That is specifically stated. And this is the ongoing process. It is not a new recruitment process. This is under some
So very good. Affidavits have been exchanged. So you file your paperwork, we decide the appeal.
in the meantime,
Post is not there.
31st August, last date of August, my lord, tenure of the study, department to the order of the Supreme Court.
31st August. So we are in March. We are in March.
Not only that, my lord, in the meantime, whichever is earlier, that was written. In the meantime, my lord, recruitment process will be completed, my lord. 25.
Mr. Chattopadhyay, your challenge is the vacancy is not within this recruitment process, which you are challenging. So if the selection process continues, that does not give you any additional benefit, because ultimately if you succeed, they have to arrange for a vacancy for you.
That was now my lord.
Which post is
But
it?
that one time, my lord, that post,
You said that it is not there.
but not for children. My lord, 100-point roster, now it is my lord, the home time, scheduled caste. So one third party interest created, my lord.
Why? You are general category.
Scheduled caste candidate, my lord, were appointed, my lord, in the meantime, my lord.
Who is for the stay?
I attempt the status on the
So
There
very
is only one vacancy allotted, and as per the 100-point roster, the first vacancy will go to the SC category. And as
No,
per-
how one point? How one first vacancy on previous selection process, there was two posts, two vacancies,
there were three vacancies. allotted.
three vacancies, three vacancies throughout the state.
any result for one post reserved? Senior reserve.
And
No, my lord, going on.
Going on.
A very short question, my lord, it was not.
Short question. Everything is short question.
Yes.
হ্যাঁ, মামলা ও বাবা কি আছে দাও সাথে
You are for?
I'm
Hari,
because my lord,
what a change, Mr.
I have taken application for intervention. Now, my lord, may I make this submission? Close, kindly take up my application once.
Which is your application? Can
Application can
and to question again. Item can to is there. আসেনি আর can to. Intervention, why? You have given copies.
yes.
Can two is not
You
in
also
the record.
my intervention.
When you have filed,
I tell you also because of this.
no, no, when you have filed,
I
it is not in the record.
there is
It is not there in our.
I care the mother mention my everything is completed.
The application টা আনিয়ে না কালকে শুনবো
The period is completed in my care.
আমরা pleading completed হয়ে যাবে।
আগের রিজার্ভেশনটা কি করে চেঞ্জ
তাহলে শুনতে ইন্টারভেনশন অ্যাপ্লিকেশনটা আনিয়ে নাও কাল সোমবার
Okay, Monday we shall hear.
Monday.
দেখছি তো চেহারা দেখো চেহারা
আমার চেহারা ছিল
Monday?
This is a Mr. Chattopadhyay, it is a matter to be decided finally. Once we start hearing, the entire list gets choked. But you are agreed about this reason that the process may be completed. Then you might face further difficulty. But I don't understand that how you would be prejudiced even if the process is completed. First, your continuance in appointment is till August 2026. And today, if they close the selection process also,
That was written in the contract. Then protect our appointment. Extend the disposal of.
that date has come. That to protect your appointment.
Because if you also taking up on hearing, August is the, before that, all the appointments are made.
Hmm.
We go.
You did not insist for any interim order earlier also. You wanted to file a supplementary affidavit. We allowed that.
Actually,
Next, actual বললে তো হলো না. Next, you have needed to be decided and charged by the interview. Continue. Yes, we have recorded it. They will continue with 31st August. সেই দেখে আমরা বলেছি opposition.
keep it on 16th month.
How many matters will hear on such? শুনলে তো সারাদিন
Starting যাবে না স্যার
Mr. Adil, you are ready.
ওনাদের পেয়ে ওনাদের হাত তুলছে
কি
পেয়েছি
Let us see the yes, tell us what.
That in fact, my lord, you are not already aware of the fact, my lord. Now, my lord, how the petitioner was affected by the, my lord, the 100-point roster as well as 2025 rule. My lord, I want to demonstrate. Dr. Kind level look into these complications.
এগুলো কি?
But one order, the applicant order is passed by the honorable. Regarding 2016, Malad, Malad, you got the 100 times, Malad, read this whole chapter. But for my satisfaction, Malad, I prepare one Malad compilation of all judgments regarding this recruitment process. First, my lord,
আমরা ঠিক আছে স্টেট জানছে ওই বলেছে সেইটা থেকে process by first week of May. Even if it is to be concluded, it will take some time. We can direct this, incorporate these things in a paper book. We are fixing a date in the month of May for final hearing. And his application will be heard along with your appeal. You may exchange your affidavits to that appeal. What do you say, Mr.
Without prejudicing from potential that Mr. Shandan's client cannot join in this business.
No, no,
Please
that
record
is
this.
that,
And then you whatever the decision was.
No, we generally do not add because he was not before the learned court
Yeah.
below.
No, no, we have.
But we have liberty to intervene.
The application for intervention. How can he tell? He's not a true interest issue.
he will make some submissions which we have to hear. That is the painful procedure we have to undergo.
I will remind these people losses in other. Allow the application for example.
No use by dividing us. Divide it to Mr. Dotto. একটা date করে দাও তো, May বলছে first week এ fifth May
But maybe only because of that was subject.
This will,
But anyway,
these are
your lordship will keep it on. Let it be.
Combined.
এটা গিয়ে শোনো না। I don't know because opposition reply has been
Yes, that's okay.
We are keeping in 4 on 4.
on 4th. There will be a combined list, but we will keep it at 2 p.m.
4 weeks. You will not be able to prepare the paper book. 4 weeks you will do.
একটা ইনফর্মাল পেপার বুক করে সার্ভ করে দাও বিকাল নিয়ে নাও স্যার।
You have been informed that exchange of liquidity.
Why Mr.
Transfer 3, my lord, that section 5, my lord, that his copy has been served, everything was blank.
No, no,
Now,
how many days delay? We rejected affidavits.
no,
First time it is done. Finally,
next week.
Well, I may not file my affidavit.
Very good. We will fix it on the next date, but you will be at liberty to exchange their affidavits in the section 5.
This content is pending.
No, content pending, it was adjourned for silence.
Yes, that's right. That's pending.
Course of hearing, it is pointed out that
Item number 9. Item number 9. I'm one of one of the petitioner responding just for
The 2 weeks, 2 weeks. Yes, next.
So for the, there is a, this has come from the Honorable Supreme Court. There is a direction of the Honorable Supreme Court that cost has been imposed that was supposed to be clear that were within 8 weeks. But Lordship, so for respondent number 10, my instruction is Lordship, he received after 3 years.
We will consider your, yes, next. Auditor.
But there is
10. Yes.
clerk of Mr. Umi Guide has requested me to make the prayer for short parcel. Appellate. Then what?
Is here.
But the clerk was here, the lady clerk was here, she requested me
What is that
for parcel.
pass over next. Yeah, just. Yes. Now, Ms. Bhattacharya, kindly just recapitulate your argument. Just one moment, just not. You are hearing impaired.
As for assistant teacher, who's not assistant teacher, hearing impaired. I am not hearing impaired. The advertisement was for of assistant teacher for hearing impaired students.
That advertisement is at page 10th of February 2019.
Yes.
That is at page.
Advertisement
6 posts were advertised.
20.
23A. Yes. Advertisement 23A.
Yes.
6 posts were advertised.
Yes. My is only restricted to this.
Assistant teacher you applied for assistant teacher for hearing impaired.
Yes.
Though you are not hearing impaired.
No. I am not getting.
Then why did you apply?
No, but that can be because the teaching procedure,
Hmm.
I am trained in that trade.
Oh, I see. Oh, you are trained to teach hearing impaired students. That's it. Then you participated in them.
Yes.
Now panel was prepared.
Well, panel was paper published, but
Panel was prepared but not published.
not published.
It was given to the state, but state did not approve it.
No, that was internal communication. And I got the knowledge that and I was waiting for that.
That is page 33.
Yes.
You have this is page 33 is a 7 January 2020
Yes.
saying that you hold a fresh selection process.
It's the government decision because there were so irregularities and nullity was there. But that state itself took the decision that this
Start the recruitment process again. Very good. Now, as per roster, it was started afresh for bringing the matter.
yes. Because my lord, this post was advertised for from the general category. But my lord, earlier also the post was advertised for general category, which was supposed to be for the reserve category. At that time, my lord, PCW get the permission. Thereafter, this time also advertisement published for from the general categories, but which was supposed, according to the state, which was supposed to be from the reserve categories, and no PCW permission was granted for that. In spite of that, advertisement was published.
Very good. Then what did the state say in this method? Please read it. Reference cited.
Yes.
Due to gross violation enter followed in process of 6
Yes.
posts.
Yes.
Your post assistant written this was no category was unreserved. 6 vacant posts of Anando Dev and the school authority shall be instructed start the afresh for bringing the matter to its logical conclusion.
Yes.
But to why it is said that you hold the selection, you said to hold the fresh selection process for reserved category as per roster.
Well, this is state saying this because that state is my lord.
State is not saying that.
Yes, ma'am.
This letter.
My lord, 33. Yes, my lord, from Director of State Mass Education Extension from District Mass Education Extension Officer. My lord,
Where is it said that it should be
my
fresh selection process for reserved category as per roster?
no, the recruitment applies for bringing the matter to its logical conclusion. Well, it was there, my lord, it was there.
Page 35 you showed us. That is supplementary evidence.
Maybe from there, that
You filed a supplementary affidavit.
it was- Well, and thereafter, once state communication was there, the teacher in charge across the mentioned matter at 38. In the meantime, when selection process was, well, the state directed to take the new selection process, well, one letter was also communicated to the teacher in charge from OSD ex officio director mass education at page 38.
This is 10th of
December 2021.
then who preferred leave to appeal? Now what happened thereafter? To start the selection. Now on 3rd of February 23, court passed an order.
Well, for reserve vacancy, finding for that, well, that is 51, 52. Well, it is from the ex-officio joint secretary and commissioner to Kajal Kumar Bandyopadhyay, IAS additional secretary, department mass education. In response to the letter, well, type copy is 51A.
So who preferred the writ petition? You preferred the writ petition.
No, well, writ petition was preferred by the private respondent
Orpita.
or and others. They are all the candidates prefer the writ petition.
Now what did the court direct?
Court direct to, but no panel was never published, nothing. Court directed in spite of that malafide violence, and the teacher in charge, though she was the party, she filed an affidavit in opposition stating all the malafides. But while the point argued from the petitioner that as the no resolution is taken by the school, his affidavit should not be taken on record. And that was accepted by the report, Honorable Single Bench. There I was not a party, though I was the second candidate as per the purported candidate. My submission is that I should be one first candidate because the Block 2 has no qualification at all to be appointed for the teacher post of hearing impaired. That I have shown on the previous day that he has the experience with regard to mental retardation. And he does not obtain 50% of graduation marks, which is the required qualification. And in spite of that, he got, and when the panel was not published, but that person annexed that panel in the petitions. when it was never published. And because this person who was attached on the record my lord, I can show that he was attached. My lord, he today I was some reluctant that the state will start.
All right, then Mr. Galib, you tell us the facts and start.
No, my lord, they went,
You will be in reply, don't worry. We have noted your arguments.
yes.
This will come in our mind once the facts are placed. Your argument has been noted by us.
My lord, I can place that also.
That doesn't matter. Let us see how we proceed. You tell us the facts and the everything. We clear it out.
Similar, I shall try.
Yes.
Similar from one judgment, appeals are three report appeals. One by the friend.
You are learned Orpita. One by Orpita appeal
It is claiming to be the second impaneled candidate.
under assistant teacher hearing.
But state has come,
Who has filed another appeal? You state.
state, that is MAT 646 of 2023.
Yes.
Why this appeal by the state? State says the entire panel has to because that
Yes.
is the product of non-compliance with the selection procedure. Selection rules. Selection bad, everything bad, everything good. So, my lord, if the panel remains, then only the question of fight between my learned sister and Mr. Pakistan will have relevance. If the panel does not, nothing. So, my lord, that's why, my lord, I was, my lord, appealing. Beseech your lordship that the state's appeal in my number of things be heard first.
Yes.
That's true.
So let us go to the order now.
So, my lord, what happened? So, this state is an affidavit in the ring. My lord,
Yes.
even during the carriage of the proceeding, the authority took a decision that yes, the selection process will start afresh. That was brought on before the honorable single bench. Honorable single bench gave an order for go ahead. Thereafter, my lord, the matter came up for hearing for another coordinate bench. And finally, my lord, the order that no entire selectees have to be given the point. There was contempt. On threat of contempt, we complied with the order. We complied with the order. So these selectees, the petitioners, they are in service as of date. Lordship knows, my lord, despite my lord compliance with the order, report appeal rights. It's a thing.
There were 5 petitioners.
Lordship,
6
there were
petitioners.
6. So, my lord,
6 have now been appointed.
compliance has been done. Compliance of the judgment on threat of contempt has been done. There was contempt application. Despite that, despite the compliance, my lord, this appeal needs to be heard and it is a settled position. It can be. We have to show the Supreme Court. Despite compliance with the court appeal, she means then also clear the cost of castigation may have been set.
It was not an ex parte order. You were present. State was there.
State, yes, we filed, we used our affidavit, contested. But before the appeal could be taken, there was contempt.
Contempt, you could have taken that point that appeal is there.
Appeal, my lord, I think it is.
You allowed the appointment. The persons have worked since then for 6 years. Now at the final stage, you are saying that send them home. I have complied on threat of contempt.
Appeal was there, my lord, but
No, Mr. Gali, the judgment which you will be placing, there is no absolute bar on threat of contempt, something which has been done. But equitable principles apply. Which is your judgment you are showing us?
Was the 9-1 and 1 double. 1 double. One double. Kindly consider 2, 3, 5 and so on. The challenge in this appeal is the judgment of the division bench of Jammu and Kashmir High Court dismissing the appeal filed by on the ground that the respondent had been considered in service, which was included in the petition, which has filed for the petition. The High Court made the appeal had thereafter become inconstitutional. Learned counsel for the appellant submitted an order as a legal order. So the High Court was that did not take away the right. Paragraph 5 concluded by the school that many cases where the law is not punished. What is implemented that does not punish it on what merits. Below C, in para 6 it takes note of a particular judgment, and thereafter paragraph 6 it takes note of a particular judgment. Thereafter in paragraph 7 above, being the position, the order of the cannot set aside the shall be not support. Lordship, may proceed. The kindly see the challenge in the petition first and thereafter we write. The same limit it will not to the judgment and the challenge. Read petition is below. Page 1, below 290. Kindly see below the petitioners.
We have seen that.
What was the challenge below? If I may respectfully invite your lordship below to the prayer clause. At page below 16. A writ of in the nature of mandamus to issue commanding the respondents delegates to receive, cancel and withdraw the bid 1st July 20, and further command the respondents to approve the panel as submitted by the school authority filling of the post of teaching and staff of Anand Dev and Branch. What is this 1st July 2020? Lordships will be find without at page 33 of the paper. This was the challenge below in the petition. It's a Miller letter from the Director of Mass Education Extension.
It is 7th January. At the bottom, page 33. Ask the typographical error in the prayer.
Yes. The typographical. Very tough. Page 33 was the challenge.
Yes.
It's a letter without analysis from Director of Mass Education Extension to district master extension office. What is the subject recruitment procedure followed in the process of filling up the post of different bands? In inviting a reference to the subject set down and understand its state, that due to gross violation of government rules during the entire recruitment procedure followed in the process of filling up of 6 vacant posts, that is assistant teacher, unreserved 1, assistant teacher, ST 1, librarian, unreserved, clerk, cashier, unreserved, peon, unreserved, night guard, unreserved. Taken bank school. School authorities should be instructed to start the entire recruitment procedure afresh for bringing the matter to the court. So this was a challenge. Now, Miller, if I may respectfully invite your lordship, let to the impugned judgment. Impugned judgment, Miller, is at Miller, case 30G.
No.
Sorry,
Come
number
on.
57. I'm sorry. Starts from page 60. Keeping the facts, Miller, may I, Miller, place the observations part, Miller? Let me present that. Page 16. The petition by filing this petition challenge a memo dated 1st January 2020. Let me again type of the petition. It is again type of the petition. Issued by the Director of Master Recruitment Extension Government of West. And then another memo dated 10th December 2020 issued by the Waste Director of Master Recruitment.
Where is that?
10th December 2021. Miller at page 39 of the paper. 10th December 2021.
What does it say?
For the waste.
We cannot read this. As per
There is a type copy.
as per the an emerging managing committee was held on
Sorry. So that is at page 38. I'm sorry, 38. From OEC, Mass Education Extension to PIC. Where you have the contest request to start a recruitment procedure. Your letter dated 8th December 2021. Appropriate to the aforementioned matter is to be informed that Shri Pulok and others have filed an application with the Honorable High Court PWP number so and on 7th October 2020 and 21st October 2020, the same application was taken over. When none appeared on behalf of the parties, the same matter the school authorities also added as is for number 4, 5, and 6. The matter is still pending. No interim order or stay order has been issued by the as it appears from the downloaded copy of the Honorable Court. It may be mentioned here that due to gross violation of government rules during the entire recruitment procedure followed in the process of filling up the selected posts of the school authorities were instructed to start the entire recruitment procedure for bringing the matter to notification latest 7 January 2020, which I will note that software is
So after giving a blanket stay, you said that you proceed with the recruitment process, which will abide by the result. In this memo.
No interim order. There was no.
No, last paragraph.
So the Cafe School Authority has not taken any steps
Next paragraph.
and it is advised to proceed with the recruitment project and until state
Procedural.
clearly mentioning that recruitment will have to be subject to the result of search. So this was the standard. Now, my lord, may I come back to the intent?
Intent judgment is not
What is the violation of government? Your only case that the selection process was conducted.
Only the observation sort of not single thing and thereafter I shall. Okay. The observation starts at page 71. From paragraph 23. Government circular dated 24th April 2017 issued by the Department of Mass Education. Enjoin the selection committee for the purpose of selection. This my lord, not to be fine. This
which paragraph you are placing?
paragraph 23 below page 71. Lawsuit find this in paragraph 23 that government circular number 237 dated 24th April 2017 issued by the Department of Mass Education Extension and libraries and government of Reservation enjoined this 24th April 2017 Lord is the procedure which your lordship will find Lord. I have placed at page 52. This is the procedure which your lordship will discuss. This 24th April 2017 is the procedure. That is at page 52. Later I shall come to what are the violations. So this is the procedure issued by the Department of Mass Education. The selection committee for the purpose selection shall take written test and interview practically the selection commission is necessary. As the selection committee finds it suitable and prepare the panel of 3 candidates in order of merit and prepare the commission detailing the procedure. They have adopted while awarding credits to the applicant candidates. As indicated above, the selection committee proceeded to conduct the selection process by taking interview personality test of the eligible candidates. Therefore, the selection process as sorted by the selection committee was in accordance with law. Our problem with this, so it was not in accordance. It is about in the application paragraph E that to the respondent number 2 declined to approve the panels prepared by the selection committee conducting lawful test. The same respondent approved the appointment of 4th staff member of Vivekananda Lok Shiksha Niketan who were selected without adopting any selection process. As to such appointment, there is no specific denial on the part of the respondent. This on cursory demonstrates that there was no impediment to the part of the respondent to accord approval to the panels prepared for. So the second issue is that learned judge was seeking a parity with one Vivekananda since those were given, it should also be given. Now, paragraph 24, it says as it appears from the resolution annexed to the supplementary affidavit filed by the commissioner. While the interview was conducted by selection committee 1, deputy magistrate representing the STO, district mass education center at that teacher in charge were present. As a relevant government circular shows, the STO with the chairman of the selection committee should remain present. The STO is not designated by any name, but a post itself. Ordinarily, when the STO is on leave or out of session or busy with any arcane official work, we delegate the authority to represent. In the absence of any document to the contrary and view, the presence of the deputy magistrate in case of STO usage should not initiate the selection process. As stated above, out of 4 members of the selection committee, 3 members were present when the interview was conducted. With the decision so division bench of High Court said that while 50% of the members of selection committee conducted a selection process by the system, selection right? Otherwise, selection was in particular. Second reason, absence of STO, no issue.
Then who was the 4th member? 3 members were only present.
Yeah, I shall. Second is below paragraph 25 is outwitting PIC from contesting the writ petition. I find that the respondent number 6 that PIC as well as secretary of the managing committee of the school contests the request by filing opposition in his personal capacity without any authority from the managing committee of the school. In the decision in the case of so and so has been held a paragraph. So we are here the teacher in charge affirmed an affidavit. The honorable single judge is of the view that no, you cannot contest. Since you are not authorized by the managing committee to affirm this particular act. Hence, the affidavit was totally outdated. Now, para 26, state also cannot contest. Why? Kindly see. State also cannot contest. Para 20, in an unreported order dated 4th September 2003, passed by the learned single judge of this school in WP number 12261 of 2003 has been held by the school that without any resolution and or decision of the whole body by majority decision, the secretary or any office bearer has no locus standi to play for the legal question. Para 27. In view of the decision as above, the respondent who has filed this is on state view. Respondent is the state. Para 27. Who has filed the opposition in personal capacity has no locus standi to file the same. That being so, the opposition ordinance should not be taken into consideration. A bare description of the opposition shows that the respondent 6 has made allegation of nepotism as to the preparation of the planets, but the opposition does not disclose necessary documents. So, will the TI's opposition cannot be accepted. State's opposition also cannot be accepted. Now, Miller Para 20 says the district official of the government is taking a U-turn. I strongly deprecate this is what always and this is 20. In this regard, a question crops up whether the respondent was free in official course of business forwarded the panels to the director through district mass education extension officer for approval can take a contrary stand in the application. Similarly, the same question crops up whether the district mass education extension officer who affirmed the affidavit on behalf of respondent and who recommended for approval of the financial director can take a contrary stand in the affidavit. The official acts or action on the part of the respondent 6 and district mass education as to preparation of the panels and recommending the panel for approval should be honored by them and they cannot take a contrary stand. So district authority has sent a panel for approval to the director. So you also cannot take a U-turn. Since you have sent the panel to the director for approval, so why would you take a U-turn and telling that there was no compliance of any selection procedure that panel has to do? This is another thing. Now, my lord, Para 29. Para 29 says on the issue of re-advertisement. The authority said that you should go for a fresh. Because the preparation of the panel for assistant teacher, scheduled trial, librarian unreserved, clerk cum cashier unreserved, peon unreserved, night guard unreserved. There is no substantial objection on the part of the answering respondent. The contention of the respondent sent us around the selection of an assistant teacher unreserved instead of selection of an assistant teacher reserved for scheduled caste. As a relevant official correspondent placed on record revealed, the dispute as to the selection of an assistant teacher reserved for scheduled caste of the application has been resolved by the backward class welfare department. Read a memo number 5th August 29. The memo has been reproduced here. So after reproduction, it says that in para 13 that says this opinion of the PCW. Kindly see the criminal PCW reproduced here. Whereas there was one vacancy available for being filled up by the post assistant teacher under the sponsor of the government. Whereas the aforesaid vacancy was reserved for its candidate, being the one SC vacancy, the 100-point roster vacancy. Whereas the aforesaid vacancy was not filled up by the school by the candidate of right community due to bona fide mistake arising out of order. whereas authority concerned has now undertaken to ensure due observation of reservation norms in future and has offered to carry forward this reservation cases to the subsequent unreserved vacancies and approach the government for regularization. And whereas the government in the backward classes will that in the interest of public service and due observance of rules of reservation hereafter, it is necessary to regularize this company. Now, therefore, in terms of provisions contained in the first revised subsection of West Bengal Scheduled Caste Scheduled Reservation. In the first revised subsection of section 7 of the as amended on time, the governor is pleased to regularize the said irregularity, subject to condition that the reservation against the reserved vacancy already filled up otherwise gained by candidate for whom the vacancy was originally reserved as aforesaid shall be carried forward to the nearest unreserved vacancy, namely for filling up SC candidate and be filled up accordingly. Paragraph 30 below kindly see, it says about fate accounts. It transpires from the documents of record that due to mistake on the part of the school authority as well as selection committee, the post of assistant teacher reserved for scheduled caste has been selected to be filled up by a candidate, unreserved candidate. The memo dated 5th August 2019. 5th August 2019 clearly states that the governor has been pleased to regularize the irregularity subject to condition the vacancy against the reserved candidate already filled up, otherwise then by candidates for whom the vacancy of originally reserved as a person shall be carried forward to the nearest unreserved vacancy, for filling up SC candidate and filled up accordingly. As it transpires, the selection committee in its official business advertise a notice of recruitment to fill up the vacancies as above in state level newspaper. The secretary of the managing committee forwarded the panels prepared by the selection committee to the director, mass education, to district mass education extension officer for approval. And the district mass education extension officer advocated the recommendation for approval without sufficient reason. Ordinarily, such officials should honor their official actions promises as depicted above. In such context, a decision has been taken, legitimate expectation. So this legitimate expectation has been taken, this was taken because to so Milord, paragraph 30 in the same way, Milord. So Milord, here the grounds of challenge of this particular impugn judgment. The first violation of the selection procedure is $100 roster has not been followed. It has also been admitted by the teacher in charge. May I respectfully invite your lordships to page 50 below. Page 50 Milord, if I may respectfully invite your lordships on the paper book. Kindly say this is a letter from the teacher in charge and secretary managing committee. And she is writing to the subdivision officer. Kindly see what does she see. Regarding appointment of vacant post of HON'BLE, I so and so inform you that during the ongoing process for appointment of 6 categories of vacant post of the school, the procedure in terms of circular number so and so dated 24 April 2017 of the Commissioner, Department of Mass Education Extension, in respect of item number 3 subcolumn 1, that selection committee will ensure the reservation status for the post and get the register of appointment authenticated by the appropriate authority should have been followed. But being the member convener of the selection committee, I am to inform you that from my end, the above standing circular was not put up in the meetings of the selection committee held on different dates, and hence the procedure of entire reservation status for the post and getting the register of appointment authenticated by appropriate authority was not followed before publishing the advertisement for the 6th post and subsequent other process in the matter during the entire selection process. Under the status circumstances, I make my unconditional affirmation. So it is an admission from the TI6, sir. The violation of Below TI is to invite your lordships to below regular 52. This is a circular that is a procedure for appointment. Kindly see below. Seventh paragraph. This is the circular by the government of West Bengal, Department of Mass Management procedure for appointment of teaching and non-teaching staff in sponsor institution for the handicapped students under the Directorate of Mass Management. I shall only refer to the procedure. The government is considering for some time to simplify the procedure. Now, after I'm reading out 5th paragraph from the 6th paragraph from the top. Now, after careful consideration, it is here the order. The following procedure will be followed while filling up the vacant schools for the students and under the administrative control of the department, with effect from the issue order. The secretary of the committee of the school concerned will submit the proposal for filling up the post to the EMPO. This is Director of Mass Education Extension Office. 3 months ahead of the occurrence of vacancy. In case a vacancy arises due to superannuation of an exam. Other situation, he will submit the proposal to the DMEO concerned within 15 days. Now, kindly see next page below. The DMEO will send the proposal to the director. So, the earlier DMEO is district mass education extension officer. All are DMEOs. So, this district DMEO will send proposal to the director. Now, DMEO will send the proposal to director. The director will seek in principle approval of filling of the government within 7 days. Now, Roman 2. After receiving in principle approval from the government, the DMEE will advise the EMEO, that is district, to constitute the selection committee. The composition of which is the composition kind. In case of staff other than the head of the institution. So here they are staff below staff other than the institution. President of the managing committee, the chairman. Secretary of the MC of school member convener. DMEO, that is district, the concerned member. An expert to be nominated by the DE of the concerned department district. An expert to be nominated by the DE. Now, my lord, may I speak? And we are draw your lordship's attention to Roman 3. Selection committee will, what will they do?
So SDO was nominated by DM.
Lordship.
Yes.
Kindly see below, the election committee will, Roman 1, ensure the reservation status for the post and get the register of appointment authenticated by the appropriate authority. It's the first duty of which they have not done.
Now, how they have not done?
The roster part,
Roster part in the earlier selection process, one general category post was filled up by an ST. That is so far as That is why it was said that that will be carried forward to
So
the
this-
next selection.
So this is the selection process going on, so this should have been, this should have had been authenticated by the.
No, this is of 2000, you are laying down the procedure in 2000. This is a memo page which you are referring to, page 52 is a 2017 procedure. Now, in the advertisement, the first vacancy is unreserved. Page 23A. Now, please explain, Mr. Gali, vis-a-vis this, the observation of the court. Court has said that as regards people, no substance now. On the part, the contention of the respondent centers around the selection of unreserved instead of selection of reserved. This was your contention. As the relevant official,
Your roster point was not at all compliant with.
how it was not complied with. It was kept as an unreserved vacancy. Why? Because the earlier vacancy was filled up by an ST candidate. Thereafter, the Backward Tribe Commission regularized that and saying that that vacancy will be carried forward to the 5th vacancy of the roster. That is what I understand.
I am showing you lordship, and this is below, so far as I have shown you lordship page 50 also.
Yes.
The TIC means answer is telling this.
No, forget about that. You tell us that how this reservation status was not followed. Why do you make such allegation? You keep it in mind, you proceed. Anything else you want to show from this?
Yes.
One point is that before advertisement, approval ought to have been obtained from the government.
One is roster point dot com. Second is re-advertisement was directed and it was affirmed by the Honorable Single Bench. That order was never challenged.
Where is that?
Although might be the final judgment. May I show that? Kindly see page 51. Kindly see page 51 minute. 51 is by the PCW. It's a memo dated 23rd September 29. So it is coming from Joint Commissioner for Reservation. This is the appropriate authority with regard to roster issue. To Additional Secretary, Department of Mass Education.
This was issued subsequent to advertisement.
No.
23rd September 2019. Advertisement was 10th of February 2019. Page 23A is the advertisement. Subsequent.
10th February 2019.
And page 51A, which you are showing, is 23rd
And
September.
because they have started all this procedure without following the roster. That is why they are taking cognizance and telling.
Where is that portion in the memo that prior to the circular 24th April, page 52, which you are placing? Kindly come to the Secretary of the Managing Committee will submit proposal for filling up 3 months in advance of the occurrence of the vacancy.
So regarding the reservation status, the selection committee will have to ensure before it starts functioning. Before it starts functioning, that
Page
is
50, page
Who
50.
have brought the for the staff.
yes.
So to post of assistant teacher, we are concerned with the selection process to fill up to post of assistant teacher. Yes, you come to page 51A. It is roster point number 4 and 5th category. That means in 100 point roster, it was the 4th post and 5th post in the school. So 100 point roster, 4th and 5th. According to, since it is a 5th post, it should be reserved for SC category. Accordingly. but they have filled up with
Unreserved.
jail category, unreserved category. Now they have filled up.
Now, that is why this is a 51 is from the
Just
Now,
আচ্ছা নিচে যে দুটো পোস্ট বললো I am hearing that two posts of assistant teacher in the school, that is roster point 14 and 15.
put in a post and
Fourth that the category 5 has to be converted to
converted to ওই আগেরটাই ছিল। What? 100% roster have you got? 100% roster have you got? এই আগের
it is there below at page 184.
আরে এই
Of the paper.
ইস্যু ওটার আগেই তো অ্যাডভার্টাইজমেন্ট
Page 184 of the paper.
one 184 of the paper book is a statement.
So even if it is assumed that fifth post should have been reserved for SC candidates,
Followed it. The lot.
if posts they have somehow as on date which has been filled up by unreserved category. Fifth. Now what court says that convert it, carry forward.
Carry forward.
The next post will be
Yes. It is not a very important issue. It can be.
can be done.
It is curable defect.
When it is done.
Not.
It was
But
previously-
whereas page 51 in your time, this is a document from the concerned authority who looks after this issue, reservation issue.
Yes.
And that very authority, PCW department says that you go for re-advertisement. 51 page 51 document is the concerned authority who looks after all the roster issues, reservation issues. And that issue is PCW department. That authority tells the DA, this additional secretary, Department of Mass Education, because these schools are under this department, that the headmistress, second paragraph, headmistress of the school has informally informed us that she has inadvertently advertised for scheduled drive and general candidates in the script of vacancy number 4 and 5. Accordingly, she has been asked to re-advertise for the
Roster point
reserved
vacancy.
post vacancy occurring at number 5 for SC candidate in cancellation of the previous advertisement. These got sanctioned from the honorable single bench also, that is will not kindly see at page 40. We came before the court, and what the honorable single bench said will not kindly have a look at that. Page 40. It was by a different bench from the one that delivered the judge. Reviewed that. Can you see that page 40 mirror? It's order dated 13th January 2020. This writ application has been filed by 6 petitioners, but 4 so and so directed to give one supplementary affidavit filed on behalf of the petitioner to kept on record. I have heard the parties. The petitioner's case is that everything has been done in respect to selection of teachers of the concerned school. There were director of mass education extension. The letter dated 7th January 20 directed the district mass education to start the entire recruitment procedure after. Subsequently, the fresh recruitment procedure has initiated as appears from the annexation of the supplementary affidavit, which is the memo of dated 10th December 2021. That is that page I have showed your lordship, page 38. This 38 I showed your lordship. Honorable single bench was referring to this 10th December 2020. Learned advocate for correspondency has raised several questions as to the earlier selection process, stating the serious irregularities and illegalities were committed in every stage of the recruitment process. Learned advocate for the state has also stated that because of serious illegalities and irregularities, the interim order at 7th January 2020 was passed, and there should be no interim order by staying the state order, which is a typographical error. Here we are talking that typographical error has been taken care of. which is a typographical error in the prayer, as an order dated March 1st July 2020, which should be 7th January 2020. As it is submitted by the learned prophet for the petition. After considering the submission, I direct the recruitment procedure, which has already been initiated, as has been stated by the respondent number 6, and also by the state, should continue, and there shall not be any impediment in respect of the continuation and completion of the process. However, for a period of 5 weeks from date of appointment, because of fresh recruitment cannot be made, because the matter is effective condition
Should continue.
So rider was added. So this order was never challenged.
So liberty was given to proceed with the earlier, not afresh. No fresh,
No aspect.
Already been initiated.
Fresh recruitment proceeding was allowed to be continued, but appointment not to be given. By page 40.
Already page 42.
Page 42.
Process which has already been initiated.
Because your page 41, it takes cognizance of the letter dated 10th December 2021. What is this 10th December 2021 that I have shown your lordship? That is at page 38. This 38 was brought on record by supplementary affidavit by the petitioner saying that, see, they are proceeding with the recruitment afresh. And this is the
but the word afresh has not been issued.
afresh.
Although,
So this was brought on record. Upon seeing this, Honorable single bench was pleased to say at page 0.direct at page 42. I direct the recruitment procedure which has already been initiated as a
Was any selection process initiated after
because we started our advertisement.
advertisement was prior there?
No, afresh with afresh.
10th of February 19. This was the selection process. 10th of February 19.
Earlier one.
Then which is the new one?
New one may not be directed to start afresh by
You directed you start afresh, but it was not started. So the court said,
start.
no, not start, continue with the process. Page 42.
Page 42 says continue with the process.
Initiated. So what is the date of initiated or date of the order is 13th of January 2022. Writ petition was affirmed subsequent to the advertisement which was made. Your circular saying that you start afresh, that was challenged in the writ petition.
No. This was brought, this 38 page 13 was brought on record by date of supplementary affidavit in the pending writ application.
Maybe what was the challenge in the writ? Challenge in the writ was 7th of January 2020.
In the writ.
In the writ petition.
Panel prepared, asked them to give approval to the panel. Panel is the scope of the writ.
Which is the advertisement for the fresh selection process which was asked to continue accordingly. Show us that. Page 42, you are interpreting that the court has said that already a new process has been initiated, continue with that. Where is that process?
one advertisement was given to start the selection process afresh. One advertisement was given. Oh, okay. And you are saying one advertisement was given, re-advertisement. Take us to that advertisement. Huh? You are saying one advertisement was given?
Subsequently, was dropped, everything was dropped. I'm trying to show that motion.
Yes.
Subsequently, everything was kept in abeyance because of this.
No, Mr. Gali, what is your argument? Court has not considered the records which were brought, affirmed by the teacher in charge and by the state. Ground of challenge. Court said that I will not allow entry of fresh document. You cannot take a different stand when you have started one thing. This is the contention of the court. Now you are saying that, see, we directed that you start afresh. Accordingly, there was an initiation of a fresh selection process, which was asked to be continued by the order of Justice Obijit Gangopadhyay. This is a- Please show us where is there any second process which has been initiated? It is It was not initiated. Even at page 51. 8 of it says subsequent.
So no fresh selection process was initiated. It is admitted.
It is admitted. Only up to that extent it was done. And
So Joint Commissioner of Reservation and ex officio Joint Secretary says that you re-advertise for the RP roster point vacancy occurring at number 5 for SC candidate in cancellation of previous advertisement. It has not been done.
That post of general.
Lordship.
তাই তো বলছি যেটা 10/2/2019 ফার্স্ট ভ্যাকেন্সিটা দেখিয়েছিল আনরিজার্ভ
সেটা কাজটা বাদ করবে একটা
So this is of 2019. Page 51 is of 2019.
Yes, now court,
Thereafter comes page 33 in the year 2020.
yes, court in this point,
No,
court
let
has,
us draw the sequence now. So after 2019, the state authority comes in the year 2020, asks for that we should start afresh. In page 2020, page 33. So this 33 became that subject matter of challenge the writ petition. The sequence of after page 51.
Now, court, page 75. Court has relied upon a circular of backward classes welfare department dated in August 2019.
May I show that at page 140?
Same circular.
That is they have not judges.
Court has quoted 142.
Page 140.
42.
Yeah, but repetition maybe.
No, 142.
The certificate.
Certificate.
No, this 142 is what Honorable Senior Judge has quoted.
No, that is backward class certificate.
Yes.
Yes. No, my Honorable Justice the judgment is
It is necessary to regularize this case as fait accompli.
This is of
Fait
2019, 5th August.
Fait accompli. So here, two posts have been filled up by ST candidate and general candidate, and no post was reserved for ST candidate. Then APT is done. What would be done? This circular is there. Now come.
This circular says, Honorable Senior Judge has drawn strength from this particular circular.
Due to bona fide mistake arising out of order, if it is done now,
To regularize.
in terms of the provision, last portion, provision contained in such and such, content
যে কিভাবে রেগুলারাইজ
regularized.
যে
Government is
fit account.
pleased to regularize approach the derivative subject to the condition that the reservation against reserve vacancy already filled up otherwise than the candidate for whom the vacancy was originally reserved shall be carried forward to the next unreserved vacancy.
That is it.
That means in that institution, if any erroneously any post is filled up, here SC candidate in place of ST candidate, you fill up either ST candidate or you. That the next your candidate, that post, maybe 6, 7, 8, that post in respect of that institution would be the first.
So remedy is fresh recruitment procedure.
For the next post,
But the next
it has already gone.
Fait accompli. Fait accompli answer.
Now please read paragraph 30. Now after this circular was quoted, court said, page 76. It transpires from the documents on record that due to mistake on the part of the school authority as well as selection of the post of assistant teacher reserved for scheduled caste has been selected to be filled up by a candidate belonging to unreserved. Next line. The memo dated 5/8/2019 clearly spells that governor has been pleased to regularize the irregularity subject to condition that the vacancy filled up otherwise for whom the vacancy originally reserved shall be carried forward. So this 5th of August 2019 memo which has been quoted in page 75, drawing inspiration from that, says that 5th of August 2019 advertisement was 10th February 2019. 5th of August 2019 government issues a circular that you regularize this by taking this course in the next selection process or the fresh selection process. So, সেই জন্য কোড বললো ফেট অ্যাকাউন্ট।
May I not give answer?
বুঝতে আমাদেরই সুবিধা হবে।
Undertaker
Election without there is violation of any procedure. That vitiates everything.
No, the court does not say that, Mr. We are not on this judgment. We are allowing you to argue. But the court said that this dispute as regards reservation has been cured, has been mitigated by the appropriate authority, so it is a fait accompli.
May I show my explanation here in the from the reading?
Now take some other point. This is here.
No, fait accompli. May I show?
No, it is a curable defect.
Curable.
Curable defect. Yes. Next roster point.
Antibiotic দিলে শেষ হয়ে গেছে সেরে গেছে। এরকম।
You have already appointed. Now the next point is that SDO was not present.
One
Although
member was not present.
one member, SDO, one member was not present.
And the court was right. There is a judgment of our court saying majority decision. Majority decision of the selection committee. Justice Gitesh Ranjan Bhattacharya, first judgment. There was a panel, 3 members in the selection committee.
Milord, may I, Milord? Respectfully invite Lord to issue of fait accompli and fifth vacancy issue. Hostile issue. May I, Lordship, privilege Lordship.
No, do you have Mr. Galib anything to
I have
say
drafts.
after 5th August 2019?
Yes, Milord. Milord,
How?
May I show the grounds taken in that? Why? We are giving Milord.
No, we are putting a question, Mr. Galib. Court says that yes, there was an irregularity, but the same was a curable one. Why? Because subsequently on 5th August 2019, backward class says that this process of carrying over can be done. So next paragraph court said it is fait accompli.
Milord, my respectful submission is, Milord, the interpretation of that particular document has not been given the right perspective.
You are questioning your own circular. 5th
Milord,
August is your
it was
officer.
said in other, Milord, may I take your Lordship to be
All right, we have listened, we have heard
only
you.
3 grounds, not from
Take,
my-
take us to the other grounds.
No,
No?
only after showing these 3 grounds, I am pushing on to the next one. Can we have a look at 3 grounds of having? Why we say this is the wrong interpretation of the memo? Wrong interpretation of the memo. I'm not denying the memo. I stand by the memo. It's a wrong interpretation of the memo.
Very. You say that there has
Milord, can you, Milord, may I take the Lordship to Milord, page 91, grounds 12, 13 and 15.
Reservation is such a defect. It is curable. We will set aside the entire selection process when it will come to a point incurable defect. There is irreversible injury has suffered the appellant.
Milord,
So
29.
there is no remedy. So set aside. Look by. But if there is a remedy,
If your Lordship's hold, Milord, that non-compliance of hostile issue is curable defect.
you have said.
No,
I have not said.
I am on that.
Which ground you are taking? Ground?
Can you see ground page 91, ground 12?
No, tell us the grounds which you will be relying upon. 91 is the memo of
No.
appeal last week.
Yes, page 91 is a memo. I am relying upon grounds 12, ground 12 means at page 91.
Right. Oh. Acha, any other ground you are relying?
12, 13 and 15.
12, 13, 15.
May I read out?
এই করতে করতে
Two
ছাড়া
positions or assistant teachers which were to be filled up by the recruitment process were
just now. Ground 12. Ground 12 কোথায়? Ground 12 তো নেই 12 in view কোনটা বলছো? Page 90.
91.
91 is the last page of the memo of appeal.
Of which may I have?
This is Orpita.
Nah, lordship can take some my paper.
বুঝো
সেই থেকে আমাদের কাছে
Oh, not,
সেই থেকে ওর মেম্বার
that's why you're not tally. But I have my paper to lordship. State this applicant's paper.
ঠিক আছে
No, no, actually, no.
আচ্ছা 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 ছেড়ে দাও পেজ 91
Huh?
পেজ 91
Yes. Ground where? Got it. Huh?
yes
Two positions of assistant teachers required to be filled up by the recruitment process were the fourth and fifth vacancies. As per the 100 points, the first three vacancies in the post of assistant teacher had been filled up at the time of absorption of the organizing staff after the sponsorship of the same institution by the government of India. So two vacancies were created due to retirement on superannuation of two assistant teachers, Srimati So and Srimati So, and were approved for filling up period memo number 3rd December 2018, concurrence of FDEO 19 December. School received sponsorship period 22nd March 1919, and approval to the absorption of organizing staff was given on 7th September 19 with 3 assistant teachers. All belonging to your category were approved. So absorption part were all were unreserved. So we are not on 4th and 5th. All 3 teachers were absorbed because of organizing teachers.
so read the grounds there.
Since these were all organizing staff, the 100-point roster could not be maintained. The resultant vacancies created due to retirement of 2 assistant teachers were denoted as the 4th and 5th vacancies respectively. Next 13. The Honorable Senior Judge has greatly appreciated that 5th vacancy, which is denoted as unreserved in the 100-point roster, needs to be reserved for SC. As a first vacancy, which is meant for SC, was filled up by an organizing assistant teacher of unreserved category. As for the 100-point roster, it is this. We have given the table. Now, Millard, ground 15. Ground 15. The Honorable Senior Judge grossly misconstrued the term fate and duty mentioned in reference to the first vacancy by the Commissioner of Reservation, inasmuch as since the recruitment for the 5th vacancy has not yet been completed, there is no question of being fate actively as noted in the order. In the process, the impugn judgment and order did swear the suffers. So 5th vacancy has not yet been completed.
Where is it? Which ground? 13.
15.
Why did you go to point 15? Come to first ground 14, which you read. Now, order of Joint Commissioner
13.
13 you read. Now read 14.
The order of the Joint Commissioner of Reservation dated 5th August 2019 categorically states.
Yes. Now come to the next page. Now therefore, in terms of the provisions contained in such and such act, Governor is pleased to regularize the aforesaid irregularity, subject to the condition that the reservation against the reserve vacancy already filled up. Otherwise, then a candidate by the original shall be carried forward to the nearest vacancy.
If vacancy by reservation,
It was filled up by a general category candidate. These three were organizing teacher, so 5th one will be ST, which they filled up by general.
Similar.
Then the governor has regularized this. Since you have filled up that post with a general category, you carry forward that to the next selection process, where it will be SC. This is what I understand. Yeah.
If there are 3 organizing feature was absorbed in the school, they are put in roster point to come to roster point number 1, 2, and 3. Come to page 92.
Ground number.
Ground number. So the first vacancy SC.
Not sure.
So this matter was taken to the government. Government said the next available unreserved vacancy is 5th vacancy. So 5th vacancy should be SC. You have deprived one SC candidate, first vacancy. 3% has been absorbed here. So your contention is that in the matter, 5th vacancy should have been reserved for SC candidate and should be filled up with SC candidate. But here, what you have done, school done, 4th vacancy ST, 5th vacancy UR. Again, government selection has not been complied with. Already filled up. Selection process completed. You under the threat of contempt has already built up. So again you have to do it. Okay, again the next vacancy. So next vacancy and next available vacancy after 5th. You fill the SC candidate, what can be done?
What is your other grounds, Mr.? These 3 grounds. Now let us hear Mr. Sannat.
No,
What he
not the ground.
বললে যে 3টে গ্রাউন্ড শুধু পড়ো, তাই তো বলুন।
One is roster point.
আচ্ছা, what other point? Another point.
Investment part.
Another point. Selection committee not of.
DM nominated expert. There was no DM nominated expert on the matter.
আচ্ছা
On the selection matter.
আচ্ছা, সেটা দেখি, সেটা দেখো,
সেটাই তো প্রথমে জিজ্ঞেস
সেটাই তো বলছি।
যে DM is nominated by DM.
No, HT is the chairman. He is a separate contributor.
Oh.
President is the HT.
Okay.
The government school is the 52. 52 may I take your question, the procedural part. 52. Lordship kindly.
52. Yes.
Composition of the manager selection committee.
24th April 2017.
Lordship 24th April 2017. Where composition part and composition selection committee at 50. This president of the MC is the SG. He is independent category.
Judge.
And DM nominated expert is another category.
President of the managing committee
Is the chairman
chair.
of the selection committee.
He is the SG of the district.
SDO.
President of the managing committee is SDO.
Then secretary of the school. Then this DM EEO is district master education. Is a district master education.
Expert to be nominated by the
Yes. This DM nominated expert was not there.
in case of other districts than Kolkata. This is Kolkata. An expert to be nominated by the DM of the concerned district. Member.
In case of
Other districts than Kolkata.
Howrah. This
is in Howrah.
The selection was in relation to everybody Howrah.
So you are saying expert was not absent. This is your contention.
SG was also absent.
So expert was there.
Expert was not there.
Expert was not there. President was not there. So remaining members, secretary, DMEO, and an expert nominated by DMEO. Now DME nominated whom?
A 4-member committee. 4-member committee.
5-member committee.
5-member committee are from 5 members.
Case of staff other than
Other than district, in case of other district than Kolkata. An expert nominated in case of Kolkata. They are a 4-member committee.
It's a 4-member committee. Case of district.
4-member committee. In Kolkata as well as in
Committee president was not there. He had a delegate.
it's a Roman 4 or Roman 5 or.
কোথায় or?
Or মানে in case of Kolkata, then Roman 5, 4 will not be.
And only 4 member selection committee for
4
this,
member.
for district. So out of 4,
How many?
HDO was not there, 2 were not there.
না না, one was not there.
No, no, Lordship.
Out of 4, one was, that is the court finding.
And HDO,
Yeah, that is what the court has found.
You are saying SDO is ex officio president. We don't know. You are saying SDO is ex officio president of the committee, chairman.
it was not there.
Maybe. So other 3 persons were there.
If HDO and DM expert are not there, so 2 were there, 2 were not there.
So
Out of 4,
2 were there. Oh. 50%.
now let us, fourth challenge is wrong advertisement. Wrong advertisement with regard to the post of librarian and clerk cum cashier. If I may show your lordship, page 23A, type part.
Acha, who said that there are 2 members in the committee? Did you bring this fact to the notice in that affidavit which was not
Milord, may I
accepted?
show my affidavit, Milord?
Page?
Milord, page 43, Milord.
No, we want to see that portion. Did you take this point?
Lordships, Lordships.
Page?
We are respectfully inviting Lordship to page 43 of the paper.
Opposition. Which paragraph? Which paragraph?
Yes. It was appointed by TMME as an authorized representative of 2.
Come to para 5. I state selection committee not constituted properly. That there was no expert in the committee while it is mandated by that the DME will advise the DA to constitute the such and such. Where the other member, where have you said SDO was not present? তারপরে অন্য পয়েন্টে চলে গেছো. This is only paragraph 5.
Milord, may I summarize my view?
No need. You tell us, we have asked you a question, you answer that question. Your answer, it seems, is in paragraph 5. SDO is not present, which you are arguing, that is not reflected subject to correction. To the expert. Right of like today, এবার আমাদের 1000টা
কালটা হচ্ছে যে অর্ডার করতে হবে, চাকরি করে ফেলেছে 6 বছর, তারপর আমরা অ্যাপিল করছি সময়
এত সময় স্পেন্ড
Milord, may I take your lordship's Milord to page 88. It's a part of the stay application, which are categorically stated.
Page 88.
The violations have been summarily stated in this particular paragraph. Stay application starts from page 87 and see.
How can in stay application? This is your memo of appeal, page 87. Why you are saying
So,
stay? That you have already shown us. Grounds
Milord.
11, 9, 12,
Regarding-
12, 13, 15.
Regarding the presence of, regarding absence of the chairman instead from
Which
the
ground you are saying?
page 88, candidacy clause G. The chairman of the selection committee was not present in the interview board.
Only one member was not.
Now, expert DM expert not present, the chairman was not present.
So it is your feelings and it is a question of fact. So you satisfied that what happened in the interview? Whether 2 members are present or 3 members are
But
present?
that was not denied. No, in the ST application it was there.
Acha, any other point, Mr.
Other point is that the pay scale of a librarian and such was wrongly mentioned in the
According to previous.
wrongly mentioned. Librarian and accountant or clerk cum cashier
What
was
is the law?
wrongly mentioned in
Wrongly,
the advertisement. Whether wrongly paid or not, that is not. Wrongly mentioned in the advertisement.
I will show it from the our what is the qualification needed and what has been advertised.
Qualification or pay, date pay.
Lordship.
You come page 45. Librarians get pay is 4100. It was mentioned in 390.
Page 45, para 6.
390, 41.
not,
See,
And qualification for clerk cum cashier, which is public and is not similar to clerk, as per the extant government order.
how?
That is at page 164. What is the extant order?
95 notification.
No, qualification.
qualification of clerk cum.
Clerk cum cashier, page
Yes,
173.
What is the requisite qualification?
There is no desirable qualification prescribed, but they have said desirable. They have made 2 parts. Kindly see the advertisement.
Where first 173.
Lord, so may I show the advertisement first?
No, again 173 you show. We have come to that page.
173 says a head clerk cum cashier. This is the only qualification. This is essay, madhyamik, knowledge and typing, age limit.
It is clerk cum cashier, not
As in the as I am referring to, as in the case of other posts, kindly see below. If I may show you a lot of page 172. And is a librarian. There is one essential qualification.
Okay,
And there is one desirable qualification.
we are talking to librarian. Post. So head clerk cum cashier is madhyamik pass or school file.
This is the only qualification.
Knowledge in typing with 40 words per minute speed. Okay, it is.
There is no desirable qualification category here.
Yes, very good, very good. Now in the advertisement,
In the case of library,
there is a desirable qualification. In case of cashier, there is a desirable qualification. Sorry, librarian. In librarian, desire clerk. Now come to the advertisement where it is.
Page 23 A.
Yes,
Yes.
clerk cum cashier. 4. Essential qualification madhyamik, certificate in time.
And desirable.
Now desirable.
Desirable.
This portion is not in the rules, right?
In contravention of this rule, which are referred to below at page 173. This is what rule below may assist your lordship. The rule starts from page 164. Starts from page 164. Next challenge is
Is a clerk cum cashier? Would desirable?
Oh, that a librarian, no?
লাইব্রেরিয়ানটাতে ডিজাইরেবল আছে
আছে
লাইব্রেরিয়ানে 170 ডিজাইরেবল আছে তাহলে লাইব্রেরিয়ান হোয়াট ইজ দি রং
Pay scale is
Pay scale wrong.
grade pay para 6. Page 45 kindly 6. Page 45.
Are in the advertisement librarian, what is the wrong? Desirable qualification has been given. This is not contrary to 173.
With regard to librarian, I am not on qualification, on grade. With regard to
Great pay. আচ্ছা great pay কি বলেছে দেখি?
only with regard to class, I am on qualification.
আচ্ছা great pay. Here great pay is not there. Where will we find this great pay?
Librarian, no, grade pay, they start from, and you see, grade pay, they have without
Page
club together. Club together. Kindly see pay scale rupees 7,100. They start from here. 237,006. Lordship got this figure. At page 23A, I am giving out.
what you are saying?
Grade pay has been mentioned as 4100 in place of 3900. As per your gown. Grade pay has been erroneously mentioned.
Oh no.
Grade pay for the post was erroneously mentioned as 7,100 to 37,600. Lordship gets from in the advertisement at page 23A that type corruption.
Page 45. Advertisement you can enter.
Page 45 মানে first paper
Page 23.
qualification. Great pay. ঠিক আছে।
Page 23 is the type copy. Kindly see below. Fourteen lines from the top. Pay scale rupees 7,100 to 37,000 grade pay.
This great pay has been wrongly inserted. This is your contention.
Lordship. And other categories,
It should be instead of 4100, it should be 3900.
Lordship.
এদের কারবার অ্যাডমিট স্কেলটা সেম রাখছে গ্রেড পেটা বিষয় স্কেলের
একই স্কেলে দিতে
পে ব্যান্ডে যাওয়া
particular scale
very good. Anything else, Mr. Bughali? No. Yes, Miss. What is your challenge? Now,
It only may not, and the parity, drawing parity on school Vivekananda.
is that you have said?
Yes,
said
that you have said.
Stated Milord.
Yes.
And Milord, kindly see Milord, page 45 again, you are my opposition. My opposition, kindly see Milord, opposition. This is with regard to library class. Kindly see page 45, para 7, another challenge, another irregularity.
Page 45.
Para 7, that the authority of the school failed to submit any document as proof of the fact that they had posted the detailed job requirements in the portal of employment bank. This happens to be the job portal of the state government. They have not uploaded it. They have not uploaded it on the government portal. Will para 8 can you see? Page 46, para 8. On scrutiny, it revealed that the authorities of the school received some application from the aspirant and even after expiry of the stipulated time on scrutiny. Para 8, the opposition at page 046. And Milord, one ground has been taken by the Honorable Single Judge. Since the district authority has sent a letter, so you cannot take a U-turn. Firstly, Milord, the state opposition has been filed by the district mass education authority as an authorized agent of the directorate. He is not filing in his own capacity. The affidavit which I am showing you, kindly have a look below at page 43.
Oh,
I am the district mass education extension officer
we have understood.
authorized on behalf of respondent number 2.
The act of the agent,
And my lord,
why shall not be
and my
bind
lord,
upon the principal?
my lord, one thing also very my lord, I should say my lord, that honorable single judge has taken this page 34 letter at page 34 from district mass to director as sacrosanct. That since you have sent a letter requesting approval, so you cannot take a U-turn. Miller, can you see the content of the letter? Page 34, Miller, can you see page 34? It is a letter from district mass education to director. What is the conclusion? Considering the above, I would fervently request you to please keep in the accord prior approval for 6 number of posts for smooth functioning. But it's a simple letter from the district authority to the director. Because as per the procedure,
Mr. Gali, this letter is of 26 June 2009.
is sending this panel, the panel approval of which it was prayed for. Approval of which it was prayed for.
Yes.
So the district authority under any circumstances is not the recommending authority. He simply sends it. The scrutinizing authority is the director and the approving authority is the department. So when does
Okay, we have understood. But you say in the circumstances, he is one of the functionaries of the state. He is acting or functioning, discharging duty on behalf of the state.
from the
Or he is acting as an agent in the proceedings of the state or secretary such and such.
to forward it.
So in a proceeding, any statement made or any action done by the agent is binding upon the principal
Done by the agent here, there is no
or functionary.
here there is
So he is acting on the state while discharging official function. Any action taken by the state shall not be binding upon the state. Tomorrow, the district inspector of schools, any action will be disowned by the principal secretary.
we are not disowning
So,
in my district.
okay.
We have heard your argument. We have heard your thing. We have heard your
We have
argument.
heard.
Yes.
He is not the scrutinizing authority.
Yes.
Scrutinizing authority is the director.
Okay,
We
They have applied their mind.
have taken note of your argument. Yes.
Yes,
Mr.
Mr. Sandal.
Mr. Sandal, yes.
So your proposal is that your second employer candidate,
Yes,
first employer candidate having no requisite qualification
yes, why not?
for the post.
What the?
Yes, he has gained
Experience in mental retardation, not in hearing.
Yes, and
Yes.
then the educational qualification also from.
You in
Fifty
reply,
percent.
yes, Mr. Sandal,
Why not?
finish it off.
The judgments are not very such.
Yes. Our judgment protocol.
You give the judgments to us. What are your differences?
With all legitimate expectations, honorable single bench was pleased to refer legitimate expectations. My humble submission is.
We have taken note of that. Legitimate execution will not occur.
Beyond statute, we are the procedure, we are not.
Yes. Give us the citations.
2025.
Say so, Anna.
Yes, give.
Give.
2025 to SEC. Page 1. Page 1. Paragraphs 25 to 27. From 25 to 27. The second proposition is selection bad, everything bad. paragraph 5. This is 2011, 3 SCC, page 436.
Yes.
Paragraph 5, 37 and 38. Below things, next proposition below, next judgment and proposition below.
All are these are legitimate expectations.
No, my lord. First was a legitimate expectation. Second is selection bad, everything bad. That is a 2011 3 SCC.
Yes.
And third and last one is, my lord, things to be done in a particular manner.
Cannot be done in any. That word procedure has been.
16.6 SCC 323.
Para?
16.6 SCC 323 para 17. Only by only beseech me, Lord, we are matter.
It was last 16 6 SCC para 70.
Only humbly beseech me, Lord, kindly, Lord, takes this aspect of the matter, Lord, that director and department, they have applied their minds because they are the authorities who are to apply their minds, whether legality of the procedure has been followed on. So we are, after the document having forwarded from the district, it went to the secretary and the director. Director applied his mind and found that all these procedures have not been followed. Because the scrutinizing authority, as per the rule, is the director. Director, when after scrutinization, he finds that yes, everything is all right, he forwards the panel to the department. Department approves it. So documents coming from district is not sacrosanct. It is sent only for scrutinization by the director. So upon scrutinization, it was found that all these irregularities were made. So that it was dropped.
Thank you.
Doctor.
It does not do that. Okay. The Mr. Galib learned advocate We are coming back at 2 p.m. Yes. No, item.
Item one.
Just one.
Oh,
একটা পুরোটা password. Where is your other side?
নমস্কার, 5/1 আছে, 10 আছে, আমি 10 দিই।
What happened? You have seen that earlier order which was placed.
Doesn't give us already decided this, but I think the settlement judgment has to observe this. Chandra right case. Yes, this
Come
was
back to
created
photo.
by this person. This case is like in the Chandra, the very particular case.
সকালে ছিল তো। Not this week. Yes. Next. Yes, item number 10. Yes. देखिए এটা।
After completion of state examination, you are appointed as judge. After successful, you are appointed as judge in a primary school under the DPSC order.
Yes.
That is on the 4th of February, 2017. Thereafter, you will see
Just. Exactly. Or ছেড়ে দাও। Yes. You got appointment when?
4th of February.
4th of February.
2017.
4th February 2017. Where is the appointment letter?
He joined on 5th.
Eh?
He joined on 5th.
Is there any appointment letter?
That is not with me.
Very good. Then he joined.
He joined.
Then what happened?
Thereafter, the Lord, he got sick.
Joined on
So, it's the
5th of February 2019. He
2017.
2007. Very good. Now he fell sick.
Sick.
Huh.
Look, the Lord, within 6 period, he went to the school, there is no allegation against him. There is no allegation against him. Thereafter, all of a sudden, he issued a show cause. He replied that show cause, that after considering the show cause, he has been issued a charge. That is page.
Where is the show cause? Where is the show cause?
I'm not trying to accept.
Do you have the show cause in the file?
Not on the file.
Then what
That
is
is from charge sheet. It appeared in charge. Charge sheet is page 37 to 39. Five charges leveled against him. 5 charges leveled against him.
Yes.
That's page 37 to 39.
9. The charge leveled against me that first charge was whereas page 37. I'm reading from page 37. Article of charges. Whereas you have been continuously and regularly being absent without any prior permission from your duty in the school since 14/6/2017, and this conduct has affected primary education in the school. This act on your part has continued misconduct, negligence, dereliction of duty on your part, that is first start, second charge, whereas you are absent from 14/6/2017 for a long time without any bad information and permission was absolutely unauthorized, and you have did it only after 4 months later from your joining to your school 6/2017 before your service confirmation. This act has continued serious misconduct on your part and ultimately rules. There are 5 charges leveled against you. Thereafter, I have filed a written statement of offense. That is page 40. Wherein, Lord, I have shown the reason against all charges. Page 40 is the statement of defense. He categorically said that I paid for holding an unconditional apology at the time of trial on 18/4/2019. That 18/4/2019 is the hearing day was fixed.
Where you are reading?
I am reading page 30 to page 40. Bottom, last 2 lines.
Yeah, wait.
For that, I paid for holding an unconditional apology at the time of hearing on 18/4/2019. 18/4/2019 was hearing was fixed. For the discipline authority, being a resident teacher of primary, I could not understand the rules and regulations, neither I could not know the same during my short period of service. The concerned doctor, by his letter dated 2012/2018, would clearly be free for discharging duty. At the same time, advised me to take bed rest and go for medical checkup from time to time. I therefore stayed at my native place and came back on or about April 2019 and made an application for rejoining on 18/4/2019. Therefore, with regard to article of charges 2, it is true that I have joined assistant teacher in primary education on 18/2017, but the wrong absence of my duty was not under my control, as I was suffering severely. Therefore, the whole absence cannot be treated as serious misconduct on my part, intentional and willful negligence. Therefore, article number 3 and 4, I replied that I humbly submit that I was seriously ill and under the treatment of Doctor of Hara and stayed there. I could not know about the training course as per WBPE notice 38/2017, and for that reason only I failed to complete my training course as untrained teacher well as on the products. Now I am willing to complete my set training course at any point after granting liberty to the functional authority to complete the said courses will be considered by serious illness. Therefore, in the above circumstances, it cannot be said that the acts I have done are physical, intentional, deliberate, or violation of
So hearing was given to you by whom? Who gave you the hearing?
Yes, the chairman also asking me to appear.
You appeared.
Yes, I appeared.
18th of April you appeared.
I appeared. On 18th of 2019, I appeared.
And you submitted the document.
Yes.
So
everything
show us those documents.
Yes.
Now you gave your reply on 17th August 21 and you immediately filed a writ petition. Writ petition was filed in 21.
After filing my statement of defense, I am directed to appear to hearing authority, PPSC Howrah, on 18th of 2019.
You were called.
I have been called.
Do you have any letter?
I have been called for hearing and I have stated on 18th of 2019, I appeared before the inquiry, before the hearing, and I have prayed for apology for my illness and of unauthorized action due to my illness. And they directed me, I have stated, they directed me to submit my medical in origin, medical certificate in origin.
So what was your medical problem?
Medical problem is pox abdomen, the pain.
Show us the medical certificate.
The medical certificate is not with me. That is in original, they directed me to submit in original.
No, you don't have copies of the.
I don't have the copy. That is with the council.
Achha, then what happened? Then in the writ petition?
In the writ petition, the Honorable Justice Sugata Prasad first and order that it was for to go.
All right. So they after the order.
46. However, it has been candidly admitted by Mr. Vishwas, who is appearing on behalf of the council, that no suspension order has been issued in date and no further order has been issued with regard to ineligibility of the petitioner to continue as an assistant teacher with the failure of his part of the complex private teachers training order suspension. There are several charges. There are the first order, the Honorable Justice spoke about the first order that for resume. I have resumed.
When did you resume? When did you resume? When did you resume?
You resume? Yes. That the letter you want to that is page 49.
Okay. Now, so resumption was on 16th December 2021. 16 December 2020. Now thereafter you got salary from that till when?
They did not give me the salary.
Very good. Now
thereafter I preferred appeal and pursuant to the order of the Honorable Justice
appeal against which order?
Against the improved order of the Honorable Justice. The writ petition was finally heard by the Honorable Justice.
Very good. Now
in personal order. That is the input order.
That is page 246.
Against
No, no, Abhijit Gangopadhyay order is in another writ petition.
no, same reference.
WPA number is not telling.
No, same reference.
Page 246, your WPA is
12693.
and Saugat Overcharge passed an order 15387. Page 44.
That is disposed of. It
So
is
it has
earlier
been disposed of.
disposed
Page
of.
44, 15387 of 2001.
So
The
it
order has
was
been passed by the Honorable Justice Saugat Overcharge.
very good. After Saugat Overcharge disposed of the writ petition, you were called for an inquiry. You were called for, that is page 48.
Yes.
Eh? Date of hearing on 23rd. So inquiry officer asked you to appear.
I appeared and submitted everything. And the inquiry officer asked me to deposit the check, practically the check asked me to deposit the medical certificates in origin. I have submitted that.
You submitted that earlier with your written statement.
In my written statement, I have said
Then what happened?
Honorable Justice Abhijit Gangopadhyay passed the
That will come later. Take us to the facts then. Then what is page 49?
I have resumed my duty. Pursuant to the order of the Honorable Justice Abhijit Gangopadhyay, I resumed my duty.
You resumed your duty, page 49, you are saying by writing a letter. That being
58 joining report here, and 58 is a statement of the High Constable, a communication showing that he
Lord,
Yes,
yes, by 12. After passing the order passed by the Honorable Justice Saugat Overcharge, page 58, 2012-2021, page 58, I have joined.
yes.
After joining, they did not allow me to take any salary. That's why I page 60, I wrote a letter to the authority to disburse my salary. Then page 67, the inquiry report has to submit by the inquiry officer. Page 67.
inquiry report was given to you.
Inquiry report dated 20 March 2022, there has been some and 100%. And I made a reply to that on The page 70 starts page 70, 71. Again the inquiry report. Then
Where is the inquiry report?
the inquiry report starts from page 70. Page 70 to 77, the inquiry report. Thereafter, I made a representation against that inquiry report, page 80. Starts from page 80. In the meantime, I have completed.
একটু দাঁড়ান।
Start from page 80. I filed the representation against the inquiry. Page 82, paragraph 5(6), I have stated. According to that method, with my presentation, I have submitted the certificates of my training. That is page 84 and 85. I have completed my training course that I have submitted along with my documentation.
What is the date of this 84?
What is the date?
4 and 85. The certificate of training.
We are asking you what is the date of that?
Very good. From issue date
26/7/2000 and 6/7/2000.
or certificate issue. Page 84, examination held on 2020 April, and the certificate issued on first certificate issued on 30/12/2020. Page 85.
Training is to be completed within what time? After the date of appointment?
No, that is not correct. I have not completed. As I do not know, as I was living at Ara here, I do not know the notification. That I have stated in my statement.
Time specified in there.
But subsequently, I have completed my the outer it was true. It is true, not in time. But I have completed my training course.
17 কুড়িতে আর 21 যদি এটা
To be accepted beyond that.
beyond that.
What I am submitting, I have completed my training course out of time, no doubt. It is true, out of time I have completed my training course. Out of time. The time has been granted by the computer. I have not completed that, out of time I have completed. And I have, in my presentation, I have annexed that, page 84, 85, I have annexed that. Thereafter, page 86, that order of the disciplinary order.
You have ever communicated that due to your illness you are unable to join duties please, during 2017 to 2021? You have ever intimated them, your employer, that due to my illness I am unable, I am such and such?
No, this is my point. As for him, I have not, I failed to inform that I, due to my illness, I went back to my native place. Yeah, I have stated in my,
So
yes, that is my
remaining,
fault. It is true.
remaining
That is my
absent,
fault. I have not informed.
so remaining absence or being absent without intimation to
Yes.
employer.
It is true.
Is
Without
unauthorized absence.
I made an absence due to my unavoidable circumstances. Yeah, I compelled to absent because my parents came from Ara and picked me up.
Okay, so inquiry officer stated that all charges stood proof.
They have said all charges broken.
Yes, they have determined inquiry officer.
Regarding WPT,
Now, what
one
is,
thing that my
okay, what is the disciplinary authority order?
I have annexed the
Come to the disciplinary authority order, page 86.
Order of punishment, order of punishment. Yes, yes. Okay.
Started from page 80. So, order of punishment is page 92. Since all the charges are proved against the delinquent teacher, and the recommendation as made by the disciplinary committee, the undersigned is hereby dismissed the delinquent teacher from his service on as assistant teacher with effect from 1st April 2019. Your Lordship, writing C. The order has been issued on 8/6/2022, but even effect from 1st April 2019.
Since when you remained absent?
Yes, my lord.
Since when you remained absent?
I remain absent. I am telling you.
Date,
In the
date.
year 2017,
Date,
after
date.
joining my duty,
Yes.
after 4 months, continuous service, I felt sick. Then my parents came back from Bihar. I have stated, my parents came back from Bihar and issued.
Okay,
You
so
were absent from 14 June 2017.
In the meantime, no, 14 to 27, right?
14th June 2017, you were
17.
on and from 14 June 2017, you were absent.
Yes.
Now you preferred the writ petition in the year 2020 before Shaugato Bhattacharya. Shaugato Bhattacharya writ petition you preferred. That is page 44. Order was passed on 8th of November 2021.
8th of November,
So after 14/6/2021,
after not 21, 17.
17,
Yes.
when did you go to resume your duties?
Well, in the meantime, they have continued to proceed against me.
No, you resume duty after Justice Bhattacharjee order on 20th December 2021. So after the show cause which was a charge sheet which was issued, showing you absent from 14 June 2017,
18 December 2021.
18th 20 আমি দেখছি জয়েন 20th December চিঠিটা 18 হ্যাঁ কিন্তু when did you go to join? That I am now, you have never gone to join.
Thereafter I will, after getting the order from
We are not on the order. We are wanting to understand that why you have been dismissed from 1st April 2019.
So many see, they should only written this, they have shown.
Mr. Gayan, we are, please answer our questions. Argument will come later. You have absented yourself from 14 June 2017. After that, did you go to school before filing the writ petition? You did not.
After getting the order, I was.
Acha, that is after the order. Now, why this 1st April 2019? Why you have taken that date?
The reason they have shown.
Yeah.
They have shown that the time limit of 30th March 2019. That is the time limit of the government of West Bengal to complete the training course. Yes. That's why 1st April 2019 they took that.
Completion of training Okay. Now we have understood.
That's why they have said 1st April.
Yes, 1st April. Yes.
সেদিন থেকেও disqualified হয়ে গেছে।
But they have issued on 2022. Issued the letter, the proceeding was going on, disciplinary proceeding was going on. Thereafter, the final order was passed. And
so why we shall interfere? Why we shall interfere? That is why
interfere from where?
Where we shall interfere with the order or interfere in this appeal? Why? Why we shall interfere? Where is the wrong?
I can understand.
Where is the illegality done by the authority? Admittedly, you remain absent.
Yes.
Admitted. What is fact? Now you did not give any intimation.
Yes.
That duty is reason I am unable to join. You did not dismiss. So this absence must be unauthorized.
Yes.
Without giving any intimation.
Intimation to the authority, or
if any employee remain absent, that would be unauthorized. Okay. Now, admittedly, within a specified period, you are to complete training.
Yes.
You could not complete the same. Admittedly, you could not complete the same within that time.
Should.
Yes, you should have done it, but you could not.
I could not, because I could not know about that.
So on or after that date, you are disqualified. You are not qualified to be a teacher. Now the authority issued show cause. They gave you opportunity to submit reply. Charge sheet was issued.
Yes.
The opportunity to submit a statement of defense. You have done it. They gave you hearing. You cross-examine the witness. Everything. Thereafter, dismissal order passed.
Yes.
Now, why we shall interfere?
I am saying that the dismissal order has been passed. My first point is this.
Yes.
First point, this is the factual aspect is this, that I have been dismissed on and from the first day of April 2019, after completion of the police. Thereafter, I have completed my training course, that is later. That is true, admitted fact. I have submitted in my representation, I have submitted. Page 84. The inquiry officer did not consider. My humble submission is this, that the first, my submission is this, that any order or any decision has been taken with retrospective effect, that is not permissible in the law. That is not permissible. We are assuming that may be effective, but cannot be permissible that you issue the dismissal or removal from service order in the year 2022 with effect from the earlier year 2019. That is not permissible. There are several judgments here, and this is the word statement. My first point. My second point is that if you also kindly see the improved order, in the improved order, not only that, my lord, I made point out only one thing. The charge sheet has been issued in the year 2021.
এইভাবে disqualified করছে for the completion of the training within the municipality. এইবার এটা তো সঙ্গে সঙ্গে
Chapter 14, you were appointed on, see your conduct. You were appointed on 5th of February 2017. Within 4 months, you started absenting.
So I was
14th of June 2017, you started your absence. You are admitting that yes, I don't have any.
Yes, I am admitting. I am not suppressing anything.
But how can we help you, Mr. Gayan?
Under compelling circumstances.
That compelling circumstance, read court in judicial appeal will not consider. If you can show any document in statutory appellate authority, he will consider.
I have people asking me, they asking me at the time of hearing on 18/4/2019, they asking me to deposit my original medical certificate.
Oh,
Original medical.
again you are again.
I have. Yeah.
If you deposited, it is your what incompetency to understand anything. If anyone asks you to deposit, you will deposit without considering that it will, I shall lose it forever.
I think
First, Mr. Gayan, you remain absent for a long period without any intimation.
Yes. That is true.
And you are not in a position to produce any medical document to show that you are.
That is true. I have produced the medical certificate before, at the time of hearing, before the authority.
Only voice and oral assertion, only except this you have nothing to show.
No, as they have directed me to submit your medical certificate in original, I have deposited that before the.
It's all subsequently planted story. Otherwise, you prove it.
That I have stated.
First, you are saying you are a teacher.
Yes.
You are a teacher. You will teach that teacher, yes, to your student.
What I am
Okay.
saying, in my statement of defense, I have stated.
Yes.
In my statement of defense, I have stated.
Future of
I have
our
only-
nation will be built at your hand. Now you don't know the notification.
I have.
And you don't know that within a certain period, I am an untrained candidate, I am to acquire the training qualification. You are a teacher.
As a teacher, I have
And
completed.
today you are from a writ court, you are seeking
My humble submission.
and favorable order.
My humble submission, don't also kindly consider it. So right. Only one thing, I was appointed as a teacher, no doubt about it. After 4 months, I do not know about the rules and regulations of the. That I have stated in my statement of defense. I have stated that I do not know the rules and regulations of the primary education.
Ignorance of law is not a good. Yeah, junior law student
That I have
to write this question.
many accepted may not be right among this, and this was the first time. My understanding is this is my first time. It is not that I have habitual no, I have habitual absentee. No. After there is no allegation. There is no allegation that after my joining I have absent. But absented only due to my, in that case, I have said.
Yes, Mr. San, what-
Okay, so
let
us hear Mr. San.
Good, but that means they are saving the judgment of the judge. This is now certain principle of law in service to students. The order of punishment can be assembled on 3 grounds. Violation of natural justice. Violation of this natural justice is very wide. Valid document not considered, that is also valid. That's a conflict. Second, my lord, perversing. This also covers, my lord, any documents or nothing. And third, my lord, violation of the mandatory provisions of the rules. Well, none of the things, my lord, have been able. Not even reported in the decision.
But why did you give a retrospective effect to the order of dismissal?
Kindly take up the judgment of Justice Shobha. Judge.
Yes.
That's the thing. Page number 44. It starts at page. I think there are other places also. Kindly consider page 46. Suspending the petitioner or restraining the petitioner from discharge his duty as an assistant teacher due to his failure to complete primary teacher's training course within stipulated time as the government. This court directs the respondent authorities to permit the reputation to resume his duty as an assistant teacher, such as subject to the final result of the discipline. So, Malab, this joining was subject to the result of the discipline. So, Malab, this joining only Malab give him the benefit of salary that we have paid. Now, as soon as the disciplinary last date was taken for continuous absence, that's the termination date.
No, that was not the last date, Mr. Last date for training. You dismissed him subject to the result of the disciplinary proceeding which you just now placed, page 47.
Yes.
So after this, he joined on 20th December 2021. Now you pass the order of dismissal on 5th of the order of dismissal has been passed on
8 June 2022. That's
8 June 2022, but you are dismissing him from 1st April 1990. 1st April 2009.
All that I'm trying to do, Lordships, he's joined, is subject to the disciplinary.
Yes, but you dismiss him from that date.
From
Prior to, up to, he joined when? He joined on 18th of December 20.
That's what I'm trying to submit with the Lordships. That won't give any further benefit. We are not asking him to give me the salary back.
No, your order becomes bad, Mr.
No, this is not bad. Your Lordships, only your Lordships can say this will be only prospective.
No, on what basis you have given retrospective effect?
It's to delinquent from his service as an assistant teacher with effect from 1st April 2019.
Where from did you get this date?
I did. Just one minute.
He was required to complete training within 31st March 2019. And hence he was dismissed from 1st April 2019 due to his failure to complete the training within that period. And hence 1st April 2019 he was the date from which he was dismissed. But the specific plea has raised by you. Retrospective.
You make it prospective. There is no irregularity in the order. Even that's the only thing. It should be prospective.
Then give him salary for 3 years.
We have already paid.
No, from 9th, he did not get from 1st of the April
He
9th.
didn't work. He didn't work, that's why.
How he was, Mr. Guy, he went to resume his duties. His allegation was, I have not been allowed. So he came to REIT court. REIT court said that when there is no suspension order, pay him the salary subject to the result of the proceeding, proceed with the decision. So as you are saying that you altered the date, it is all right. So if we altered the date from it will come to 1st April 2019 to his date of resumption, that is 18th of December 2021. Give him 2 months.
Provided he has work.
He has
not gone to join him.
That is, you have not preferred appeal against Justice Hogato Bhattacharya's order.
No.
So you accepted that order. Yes, now I will allow him to resume.
And we immediately resume.
No, that is because that phase was the illegality. That period you did not allow him.
That's probably not the finding.
Huh?
Of the learned single judge finding was not there.
No,
That he was not allowed to join.
Otherwise, why he will give
The
it?
learned single judge only passed, gave him the charge sheet. He replied, you did not proceed further, nor you suspended him.
No, suspension is a
That's
matter of
Mr.
This what you are saying is that he did not come to join. I did not take his service, but at the same time you did not suspend him.
That doesn't give him the right to some salary.
Yes, you just now said you altered the date. We will
So
give.
that's also prospective. Between that period of paying. From
Yes,
Justice
so-
Bhattacharya's order till termination, you paid him.
No, you paid, right? But you should be paying from the date which you have dismissed. That is an erroneous date. So you pay him from, you have paid.
It's allow us to take a suffer for even not performing duties, we will allow them. He didn't work. This is
How
not his
can he
case.
work? He was not allowed to join.
No,
He was
I
not
am
suspended.
case.
Come to the order.
That is not allowed.
Page
I have
44.
wrote a letter. I have joined because we.
Word কথা বলে। Please take your seat now. On receipt, reply was offered. It is submitted on behalf of the vendor. No suspension was issued, and there was no formal order restraining him from resuming his duty. So, in reply to that, it was submitted that yes, no suspension order was issued. So, what we are asking is the order of termination has been issued in 22 with effect from April 1999. Now, from 18th of December 2021. You have paid him salary. Till date you have paid, till dismissal. Now he is not entitled to salary because he is being retrospectively dismissed. So you take instruction, you give him this.
And now I give the, why the chairman has taken that as a prisoner, can you come on it?
That my brother has told you.
That's
That
a-
what is the reason? Because he was ineligible to work beyond that period since he has not.
Send the government.
That
That's
the,
why.
that will be decided in statutory appeal. We are not in that. But this you rectify. This only this period you give
There is no
If you
statute.
could have stayed this with immediate effect,
immediate.
then that question would not come. Now the person will, if he would come with a requisition that give me salary,
Salary against work, this is basic principle.
yeah, then you could have taken this decision.
Because I have taken a date, either wrongly or rightly. Unless he can show he work, at least he will not be entitled.
Are how will he work, Mr. Sannal? He was not allowed to work. And that stand established because court took cognizance of this fact and said that he is not being allowed to resume. You have not suspended. Only that period, Mr. Sannal, you tell us.
No, may I point out to your lordships, according to his choice, when he went to join.
Saugata Bhattacharya's order.
Just like that.
Page 45. Repeated no suspension of review and there was no formal order restriction. সেই জন্য
Mr. Sannal, he remained absent for quite long time. You even did not place him under suspension. Even you issued a charge sheet in the year 2021.
21
5th July 2021.
এখানটায়
Before that,
স্কুল করছে পেনাল্টি
before that, you did not take any steps. You are also silent.
I tell you,
He
lordship,
is enjoying.
why?
Yes, yes.
If I place him suspension, it will put me under obligation to pay suspension amount.
but that should not be your headache. That is the government's headache.
This is, that's government headache. I am moving of the
Then
government.
suspension
Then
down
what I have to do, I have to charge him. He didn't render, he will not be automatically entitled to salary. That's the normal law.
We didn't follow. What is it?
So I issued the charge sheet. I did not suspend him.
Right.
He didn't work. Suspension.
How can he work, Mr. Sannal? He was not allowed to work.
Where is that finding?
Oh, that is I am showing you. Page 47, kindly see. You are unnecessary. You are thinking that there is nothing the judge is saying you pay. Not that. Kindly from discharging his duties as a due to failure. This is ODL. Finished. Now next, this court directs the resort to permit the plaintiff to resume his duty as such and such, subject to final result. Now kindly come to the previous page. 45, page 45. Reply was offered to the disciplinary authority. It has been further submitted on behalf of the plaintiff. No suspension order was issued and there was no formal order issued restraining him from resuming his duties as an assistant teacher. That is why the court said that when you have not allowed to resume, you have not issued any suspension, pay him this.
Sir, where is that case made out in the proposal and the single judge?
Otherwise, the judge couldn't have.
When he allowed to join and he did not
No,
allow.
Mr. Shah, if you seriously argue on this point, we will accept. He has finished his argument. Only on this point, we are also not bound to going into the details of it. Statutory appeal will like. You take a decision, modify that. How many months salary you will be? Give him that salary. That is 2000, or the justice, so he joined on 18 December 2021, and you have penalized him from 1st April 2019.
Well, Justice Bhattacharya's judgment, I take your lordships. 8 November 2021. 8 November 2021.
Justice Bhattacharya, that is page 44.
8 October.
8 November, no, right.
Oh, no, November, yes, November.
November. Now, your lordships kindly one page, page 72.
Page
Page 44.
Yes,
Paragraph, last paragraph, page 4. I further say I could not move due to lower back pain and
Page 40, page 41.
Page 40.
Page 40. Yes, I further say I couldn't.
Further I say as I could not move due to lower back pain and irritable bowel system, I was unable to continue my duty. As I was also going through acute depression, I could not inform the school authority and my concerned SI. So for that, I prayed for holding an unconditional apology at the time of hearing on 18 April 29 before the disciplinary authority. Before being an assistant teacher, I could not understand the rules. And a concerned doctor by letter dated 12th of December 2018, though declared me fit for resuming, at the same time advised me to take vacancy and get medical checkup for that. I therefore stayed at my native place and come back honorable and made an application for rejoining.
So, out of time appeal to allow him to join on 18th April 2019. Out of hospital.
Do you have the writ petition copy? The earlier writ petition copy, do you have? WPA 15387. Sugata Virgins passed an order, lordship. Ache, writ petition.
If I am not wrong, during that period he underwent training.
Underwent?
Training.
Don't say all these things, Mr. Sharma. A teacher, you are
So any document?
21, he underwent training.
80?
21. 2021.
Yeah.
That's 2 years old.
21.
Discipline calling a lot of
Few touch.
rare. Rare. Everybody come and goes,
We
nothing.
will count your appearances.
No, that's your lordship illegal appointment.
Yours is not
এটাও কিন্তু পারবে
Illegal. Kindly
রেগুলার কোর্স
regular. What say?
the present appeal has been referred.
identified this matter. Number one,
Mr. Lady, how can I hear the matter? I am a member of the administrative committee of this board. It has been assigned to me to this bench.
There has been a section also after the application. I understand.
Oh, rejected.
Challenging
It was disposed of.
disposed of directly to the High Court administration to consider
Consider.
after consideration, assistant has been given, but inquiry given rights to fresh further action.
Then will you withdraw or we will pass on?
If you have this disposed of, that I can go and no order. Again, my lord, is again assigned to some other.
So, restrictive.
Since your lordship is not only paid, merit of the matter, merit of the matter. Basically, proceeding.
Mr. Lady Learned Advocate, appearing for Mr. Lady Learned Senior Advocate.
Number two, Mr. India Media Services Private Limited.
Yes, what happened?
The books is on. What passed?
देखिए ऑर्डर शीट देखिए ठीक से
That went. Then passed and under the.
yes we heard it.
Yes, your lordship.
Ashok, today an adjournment has been prayed for on behalf of the appellant. Though Mr. Dotto, learned advocate appearing for the respondents is present. In view thereof, please the matter for further consideration 4 weeks since. Yes. Sorry, a confusion. The surname did I? Mr. Dotto.
Yeah.
Confusion. Madam, we are not sitting regularly. Ask Mr. Ghosh to give a notice and come back. We will fix one day then there.
B and 4, city enclave private enclave.
এটা তো সেই ইয়ে না, এটা দেখি। Yes, Mr. Where is
Why not in the assigned matter? Why does it take hardly 50 minutes to the matter? I can assure you, hardly 50 minutes.
Mr. Banerjee? You are for the appellant?
No. He's for the appellant.
City enclave, Mr. Who is appearing? Where is Mr. Mithri? Sir, we don't sit regularly in original site, no?
Hardly will take 10 to 15 minutes. I can assure you.
একটা order লিখে নিন, ওই same order করে দিন। Today, an adjournment has been prayed for on behalf of the let Mr. Otherwise we cannot hear. No?
Very short point, 10 minutes.
He is the appellant, we has to start.
Yes.
You mention after 4 weeks we shall include it. We can
Instead of 4 weeks, can you just
let it. Yes. Sir, you can argue. All right, not today. Not this week. Next warning list dismiss করে দিই। ওই যে অর্ডারটা লিখেছিল তো
না ওটা আলাদা হবে
এটাতে কি করেছে?
Sorry, 14. And was 13. Respondent, you are not the respondent.
And who responds?
Who is not the applicant?
তেরোতে বলছি চোদ্দ বল হয়েছে
Sir. Yes, you are in item number. We are called item number 14.
14.
We kept it next week, sir. He was seeking an adjournment. Yes, next 14 take. এটা রেগুলার কোন সালে? ওই যে তো আমার
আপনার
এই কি আমার অর্ডার করে বের করবো না এমনি ডিপার্টমেন্টে পাঠিয়ে দেবো? আমার অর্ডারের লিস্টে আপনি huh? By me? তাহলে লিখে নাও আইটেম নাম্বার 14 এ লেখো the order including the present appeal has been passed by one of us.
Recruitment process, the admit card, the petitioner.
Then what mistake I have committed? You have come up in appeal against my order? Chalo. Mr. Dasgupta, you have filed appeal against my order? All right.
We shall see other
That is realized that we have come to.
Huh?
Probably we have got appointment of.
It is coterminous with my
follow.
না লেট একটু দেখো তো আমার অর্ডার কি না It's my order, so it will have to go before another match. Yes, next 17 টা দেখো আমার অর্ডার
দেখে পাঠিয়ে দিই সব 20 সালের অ্যাপিল 120 পাঠিয়ে ঠিক
সেই জন্য dismiss করে। দেখেছো সন্দীপ ব্যানার্জি না না আসে
মাইক্রো আইটেম ডান না
হ্যাঁ আইটেম 18 তাহলে ওইটা অর্ডার করে ইয়েস 19 ডাবল
Yes.
You are ready, Mr. Mantha?
State is perhaps this will kindly see your lordship's last direction.
We've called for a report, no?
Yes, from the KMC and from the state there has been an
Got
earlier
it.
direction.
Have you shared it with Mr. Mantha?
Because I have some.
Also very
State of birth. I'm not having the hard copy.
Now, what is the report?
Report is that the lordship of
Land in question belong to?
has been handed over to the KMC.
Oh,
So anything that has been done, seriously KMC is contested that and this land is PW.
PW.
Cannot take it.
RR department.
RR department, refugee rehabilitation. And now KMC has done anything. KMC, we told Mr. Ghosh also to come with a report. Now, did we, yeah, what was our last?
Election, there was a election upon the state file.
But if you kindly see the state report, it's found that there are encroachments on that particular premise.
So you do one thing, you give the report copy to KMC advocate also. Mr. Ghosh is there, na?
Have you handed over to Mr. Ghosh?
I haven't yet submitted it. Because after the report,
No, no, is it with you or it is not there?
lordship, gives me.
Chamber,
I was just about.
it has been affirmed.
It is in the form of an instruction.
To instruction here.
And I have handed over the instruction.
Directed to the,
Instruction.
delivered to the,
Oh, it is addressed to the advocate.
so you file it,
Only a cost title has been. That too, as of the writ petition's cost title has been.
So
so you file a report in form of evidence. Because this statement should come in form of affidavit, so that we can fix the liability. Yeah, that would be better.
where is the order impugned?
That's the order. Fine, trying to take a look at minutes. Whereas 7th of August 2020, the lordship will find it in 17th of the paper.
It's 1/7.
Yes.
Hmm.
There's a judgment dated 7th of August 2025 and then your lordship this too. Your brief.
Yeah, take us to the last portion. You are the adjacent owner.
I am the adjacent. I am residing as a plot.
So
Right.
where it is said in the order report, it is already on the report.
Whether in their report, filed before the learned single judge, whether this fact was stated that this land was handed over to the KMC?
Yes, yes. This was handed over a copy of the report. Yes, I see your lordship, but it was the heading of the report. In connection with the read petition.
No, come to paragraph 23 of the judge. Place 23 and 20.
Well, it's page 23, your lordship.
No, page 20, read from para 22.
Thus, taking into consideration the two pictures.
No, 21, sorry.
This clearly shows that some projected portion of the tin shed at the roof level of the shop in question were found on joint inspection, which is supported by picture annexed to the exception. Thereafter, your lordship sees para 22. It is further noted that construction has been made at the ground level on the above stated record road. As such, on seeing the pictures placed by the petitioners and the report of the Calcutta Municipal Corporation, it is before the court that at present there are no shopkeepers at the ground level of the said recorded road, which were removed by the shopkeepers as per direction of the High Court, and only the projected portion of the tin shed at the roof level were found. So, but I tell your lordship, if your lordship,
So then where is your building situated?
my building is situated, whereas this is on the footpath, this is on the footpath.
Road bolche.
Maharaj, we kindly just
Ground level. In the ground, is the property just adjacent to the footpath?
Yes, yes. It is
So
just adjacent.
is there any map
Maharaj,
here?
Maharaj, we kindly take a look at page 139 of the paper.
Then we will read it with the map.
Yes, kindly. And your lordship will also take a look at that report once, because for the state.
Now this is the road. Which is your portion?
Maharaj, my portion, Maharaj, will see this EP number 1298.
Oh,
That
that is your very good.
The road right in front of that, Maharaj, is rather a portion of the public road, on which I am alleging that there is an illegal.
On the footpath.
On the footpath. On the footpath.
So now what does the court say?
Now the court says, Maharaj, that there are tin sheds or there is a procedure that
At the ground level. So at present, the unauthorized shop rooms do not exist, but only the tin sheds at the roof level are in existence. Is this right or wrong?
Maharaj, I see this.
Uh-huh.
I see it's incorrect. Maharaj, this finding is.
The shops are still there.
Shops are still there.
So you bring photographs.
Maharaj, we'll see the report of the state, Maharaj, because your lordship said directed the.
Now next paragraph, what did it say? On the next paragraph 23.
Maharaj, okay.
Who are you? You are a businessman.
No, I'm a resident, Maharaj. I reside over there. I'm not a businessman. I reside over there. It's my residence. Maharaj, the land is
আচ্ছা তারপর কি constant setbacks and report of KMC retification disposal there shall take necessary steps for removal of the tin shed.
Yes, of the tin sheds. But Maharaj, my contention before the report was that it is not just the tin sheds that are remaining. The entire shop room that has been
So you have come up in appeal disputing the fact that there is no illegal encroachment on this. This is your case.
This is my case. That
So why they are having no grudge against you? KMC or state has no grudge against you. Then why they will say something wrong on affidavit that present there is no illegal encroachment?
But I bow down to your lordship. Even I bow down to your lordship. Because today I tell your lordship, where the dispute arose was with regard to the road width. Initially, whereas your lordship will see that we contended on the basis of sanction plans given of adjoining plots that the road width is 60 feet. The KMC went ahead and said that no, look, the road width is now 52 feet. 52 feet. Which is why whatever has been constructed is beyond the 52 feet, which is not within our jurisdiction. Whereas my contention is that the road width is 60 feet. There is a footpath, and that malas and the construction has been undertaken on top of that footpath.
Then you have implemented any persons who is illegally encroaching? Have you?
Yes, the private respondents are
How
available.
many private respondents?
1926, your lordship will see they are the private respondents.
So they are the running the shop.
Yes, they are running the shop. They are running the shop. My ingress is also being hammered. So my gate is from.
Yes, what do you say? You are not on that portion.
But I am occupying that position.
You are occupying.
Yes, I am occupying that position.
Then how does
Because I am
the
in position of that position since not last 40 years. It is not going to your lordship knows this is that RR department.
so
Act.
what protection you have taken?
Well,
You are encroaching upon the property. What protection you have taken? Did you go to the civil court?
but your lordship, this is RR department land. But what all your deeds are executed, this is a possession. No separate.
You have patta.
So I still do not have patta because commercial pastas have still not been given. If I am ousted from that possession, I will never get a patta. The consideration for my
So
patta
there
is
must
not
be
the patta in respect of which land patta is getting. But they have respect of
vested land.
possession, they will in respect of footpath. This is not a footpath. This is an RR property, RR land. The land says
So the government says that since the road has been handed over to PW under is no longer under control of PWD, it has been handed over to KMC.
and KMC says, you know, that's we are not in their property. KMC has said that we are not in their property.
But your existence is there. You are admitting that you are occupying.
But I am occupying.
Under which authority?
Under which authority?
Unauthorized occupant in government road. In government road.
Not government road. That's exactly what my submission is. I am not on government road.
So you settle your problem giving a passage of ingress and ingress.
He has a separate passage. He has been using that passage for last 50 years. Today he wants to once a showroom there. That's why he wants to throw me out.
Showroom of what?
Whatever commercial purpose he wants to use this property. He's entitled. He's entitled. But the problem your lordship has been to Hathibahar. Your lordship has been to Hathibahar. Because there what happens is the big shops.
Can't you settle it?
But it's not about it. But it's a kind
No, no, is there any possibility of settlement? That if you want some Mr. Mantha, this is a thing, they will say it is a civil dispute. Once
I understand. I see what is going on.
please talk with your client that this situation is not from yesterday. It is continuing for quite some time. You are languishing in this court for more than 10 years. I
Yes, yes.
So, what is the requirement of your client? What does he want to say?
Now, Malas, the problem is this: he's residing at the property. There
You
is
talk with your client.
I'll have to go to
Have a word with him that court is wanting to know that if there can be any settlement to that effect. If at all, that if at all possible, suppose my ingress and egress has been closed, it is a very serious thing. So as my brother says that he has to prove authoritative documents towards his possessions. But these persons maybe they are on the road for say more than 20 years.
yes, yes.
So a settled position, if you unsettle, there will be commotion disturbance. So, but if you say that yes, if you can do this thing for me, I will not be disturbing any further. We are trying to settle.
Yes, yes, yes. I see, and I completely got it. I will take instructions. In fact, I will ask
That my ingress and egress is only 2 feet. Give me, I can share with you that day I was visiting
That is the portion which is designated for being used as a footpath. For the common people who use the footpath is not belong to any person. Maybe it is under control of the government, but it is meant for use of the common public, common commuters of the who will able to. That whether how you can encroach any portion of the land which has been given for
From your lordship,
use of common public
now, Lord,
and use it as a owner thereof.
footpath and your roads have been vested with the Kolkata Municipal.
Mr. Kormukar, what is the finding at page para 21? It
Give
says
a
that
copy.
the ground, in the ground level, there is no construction. There is a, now tin shed you have removed.
I've been yesterday.
Then let us understand that it says that some projected portion of the tin shed at the roof level of the shop in question were found on which is supported by picture. It is no construction has been made on at the ground level on the above stated recorded road. This is a finding. So you are saying
Projected.
no, not projected. No ground floor.
Construction has been found on the ground.
Then where are you occupying?
So that's exactly what I'm trying to impress upon.
What?
The
What?
land on which I'm occupying is a land belonging to the RR department,
We have heard that.
not to the
Court comes to a conclusion that in the ground floor there is nobody. 7 exit there is a protrusion of a tin shed. Why was the tin shed placed? Maybe for somebody to occupy there.
No, it's not like that. I indicate.
Have
It
you
is like my shop is. So the photographs also. So the shop ends here. Here
Where is this photograph? Mr. Mantha. Where is the photograph?
That's when guys just see cat one have annex picture colored photographs on it.
camera.
No, the cat one because those of people they had black and white photographs, we can record the colored version of the same photographs. I just had I brought to the cat. That's all.
Yeah. Ground floor shop নেই এই যে প্যারাগ্রাফ চালাচ্ছে ওদেরকে
Your Lordship, see this Lord? Photograph. Lord, I am occupying this portion.
সে কি
Where is that photograph?
এখানে নেই
Can have
can one
only
nearby
the portion of the tin was encroaching Lord upon the road. That has been removed by the corporation yesterday. I have taken instruction. That has been removed by the corporation yesterday. I have
আচ্ছা
taken
আচ্ছা
That was just 91.
না মিস্টার মালদা এই টিমটাকে উড়িয়ে দিয়েছে এই যে এই বাড়ি
Look, the same thing had happened. Look, the previous litigation took
এটা ওরা এই টিনের তলায় গেছিল এখন তো দেখতে হবে
So the same thing happened with the previous litigation took place in the
না মিস্টার মালদা it says that the tin shed is remaining. There is no encroachment. But what did the PWD say? That encroachers are there. It is we have handed over to case. No. Now please tell us, is there any structure beneath this tin shed which there? Huh?
That is what I'm trying to say. There is balance.
No, he says why he is an officer of this school, why he will lie
No, I
before
understand. No, that's part of the No,
Hey,
Lordship will kindly consider.
এই রোডটা তো এইটা
রোডটা এটা এনার বাড়ি ওর বাড়ি
তারপরে নির্ঘাত ওখানে দোকান ছিল
হ্যাঁ দোকানই যাবে
তো ও বলছে তো there is nothing in the ground.
No, এটা so why tin shed use or what
of the shed for
to shed something from sunlight and from rain.
yes.
So something is there.
That's exactly what that's exactly what I'm trying to say. This is the structure.
Acha, Mr. Mantha, can you take a snap from opposite the road?
Yes, Manoj.
That this was the tin shed because Mr. Kormukar says tin shed has been removed.
Remove in the shop room that the ground level are also are not in existence. I'll take a photograph from the front side Manoj and I'll add it. I'll do that.
So kindly comes to
Now, Mr. Kormukar, we will record your submission that beneath this tin shed which is shown, there is no structure.
So my submission is not that. Look, may I clarify? My submission, there is a structure. Thus, beyond that structure, the station is projected.
Structure means then you are, this is the portion you are occupying. Behind
It is just beside the road. Now, kindly takes page 155 of the paper.
No, we will go to that. We are wanting to know. This is Mr. Mantha's house.
Yes, it's right behind this.
Achha, right behind. This tin shed,
Just the space between
you
the
are,
road and
please assist us. Why should unnecessarily a tin shed be placed to save something from the sun and the rain? So what structure you have with this?
structure is here not your lordship. In the report, kindly take
Are forget our report, sir. We are trying to solve your problem.
the picture is from the report your lordship will find. The manner in which the pictures are there.
This first submission that my Mr. Conrad made was that there are structures that are lying. He's saying that the structures are lying on RR. That is his submission. He's not saying that there are no structures that are lying.
What structure is there?
But it's a shop room. That's what I'm saying.
But if the tin shed has been removed, what is the present position now?
But it's perhaps the shop. Just the extended portion, but still now the shop rooms are still lying on the footpath. Your lordship will just take a look at the report of the state program.
Kindly not takes 155.
Acha, Mr. Mantha, you bring photograph from the opposite of the.
But just one moment, Paras, just take the state's report for a moment. The state's report that was just handed over to you. Kindly just takes a look at that report. Well, kindly let's be clear. The road in contention, Raja SC Only Road, is no longer under the control of the PWD. It has been handed over to KMC in 2007. Second point, since the road has been handed over, the encroachments in the roads are also not under the administrative jurisdiction of the PWD. 3. As per spot inspection undertaken by PWD, you are also to note that there are some encroachments of shops in the footpath, 9 shops. But since footpaths are a part of the road, their jurisdiction also lies in the KMC. So, Malak, my submission is that my learned senior's contention that this is perhaps lying on RR land. There are some structures lying. His contention is lying on RR land. That has been completely nullified by way of this.
And that has
Because there are structures lying. There is a tin shed on top of the structures and it is on the road.
Lord, may I? Lord,
Now it is beyond this tin structure, there are other houses also. Adjoining the footpath, there are all shops.
Yes. But as you kindly see the photograph, and see this car over here. This car is the road balance. And beyond this one, the footpath begins. The footpath begins and the shops have been constructed all the way up to my gate.
let us not.
I'll bring a copy of the photographs from the other side of the road for your lordship to listen to.
Let us see what is on record. Lord, let us see what is on record. Lord, first, let us see what is on record.
The
Kindly
state's
come
report
to
is also on record.
155.
The state's report which your lordship has pointed out is on record.
This issue, this issue was completely addressed in the previous litigation. Look, the order records
What can be done?
155. May I read it out to you?
One section of people only will say that we have to save our livelihood, we have to acquire the footpath. Whatever it takes, only the way of the source of income. So now we are living for years, so save us.
We have learned from ship, not the Olga Tellis matter. We have learned from it, ship, not the Olga Tellis matter. Now, look, here, this issue has been completely addressed in the previous litigation. The court records, learned advocate appealing for the private respondents are.
Where is Mr. What is your instruction?
There was some projection, but
So come and tell
I
us.
have my report right now.
You have your report.
Along with photographs. I just
So then you do one thing. You share your report with them, and come back, and we are recording your file.
yes, Lordship, kindly record.
There's a report in the form of an affidavit.
Not an affidavit, but it's a report along with photographs. It's a report along with photographs.
You can share to the reputation.
Yeah, moment, I just get the report right now.
We have already been here for 10 minutes.
I tell your lordships.
And that 1 second is over, sir.
That I should get outside. The findings of the learned. Which I'm saying, is that today the learned single judge finds that there are no shortcomings in existence.
It is-
I say
it
that
is
on
a-
the basis of whatever finding, contradictory findings that I believe for us, that finding is erroneous. I've come up in a week before your lordship is pleased to direct the state to submit a report to ascertain the actual position. Now the state has filed a report and said that well, there are encroachments. That there are encroachments on the footpath. So today it cannot be said that this matter has been decided in finality. It hasn't attained finality because perhaps the finding of the learned single judge is erroneous by virtue of the state's report.
But if once may I ask a question to myself,
The state is submitting a report today before your lordship and saying that there are.
the state says that the portion there occupied by us is not within their
as to whether the dispute can be resolved in any other manner or not.
Well, since it has fallen from my laws, even after I'll take those instructions.
Litigation will remain. Solution of the problem is the thing.
Yes.
You are an owner, we appreciate your inconvenience, your ingress, egress, etc.
Yes.
And their problem is they are doing their business in an illegal manner. Now it is a question you have seen in Gorihat also.
Yes.
It's a very
I completely understand. Even I understand the decision of but that is also which my learned seniors like learned seniors citing. I tell your lordship, what I can do is this. I take instructions, fellows will kindly give me liberty to take instructions and come back. And in the
You
meanwhile,
take
fellows,
instruction?
bring those photographs because your lordships are calling for it, fellows, I'll take those photographs from the other side of the room and show to your lordship. In the meanwhile, if this matter can be resolved now, I'll take instructions.
once the issue of blood possession has been decided by this honorable.
Wait.
Well, it's just one.
Hey, Mr. Where,
Well, just one people indulgence for it. What is falling from my law is perhaps a slip of settlement, and even I would want that.
No, we are not recording anything.
No, your lordship doesn't record that. The only thing that I am suggesting is that my learned senior Malaj should instruct his friends. What is happening is, Malaj, that the owners of the property, as soon as they're entering, because we are litigating as a they're being abused day in and day out. They're being abused on a day-to-day basis by the shop owners. Whereas there has also been violent attacks. I'm not trying to join issues with my senior on that. If that could just be avoided. If the shop owners would just not create that chaos because it's becoming difficult on a day-to-day basis to enter my own house. That is one problem I'm facing.
No, where one person has come before the court to seek justice,
But I
whether
do not have any instruction.
it is
But then I
any criminal offense or any illegal act.
all my clients are doing or not, that also I require a certain. It's a statement from the bar.
Yes,
It's not known.
But I'm not saying that this is. I understand my learned senior's predicament as well at the moment. If he could just take instructions, then if that matter could also be resolved.
This kind
Then
of
will
matter.
come and say that I am abusing.
But at least
Yes, sir, I am abusing. Yes.
Just be prevented. That is a
This is a social problem.
The best thing which has fallen from my lord, if that can be.
reports none from this.
So you file a report in the form of an evidence.
Because there were 3 reports filed. One on 7th of January.
By the state.
The corporation. No report was filed by the state.
All right, let us call for a report from the concerned PWD officer. Who is the person?
One more thing, if I can ask a question to myself. Once the state says that that particular portion is not within their jurisdiction, how can they say that we are encroaching on something else is happening? Because the state is saying it's not within my jurisdiction, corporation is saying.
It is also statement from bar. It is also
record. This statement is on record. This statement is making this is on record. Corporation has filed report indicating
land belongs to
department.
land always belongs to state. Private land and government land, except KMC is nothing but a parastatal of the state. He has given certain jurisdiction to exercise. And accordingly, certain land has been given. And certain power has also been. Ultimately, land belongs to state.
But the state is silent here. PWD has come forward. It's not silent.
PWD is instructed.
RR department is saying, RR department is saying that this is not our land.
Have you, yes, you have got your report.
That's covered, in fact, when I getting the details, but he has given a report. Because you lost it, the direction was limited. Maybe not.
Or you give a copy to as a document as submitted on behalf of the state and the KMC are taken.
The old constructions of
Well, new construction is the finding of the KMC. The existing construction remain as they are.
But existing construction has been
Achha, wait.
decided by this order.
copies of the same head.
Session has been handed over to the land.
Photographs are not even finished. Well, the only prayer is let a detailed survey map of that concerned PWD officer, let him bring up that road. The road will
Not required, Mantha. Mr. Mantha, we will decide whether we will ascertain whether some structure must have been there and it is existing.
Yes.
So we decide it on merits and finish up instead of requesting and anything will not happen. But we will ask you.
Eviction.
Wait.
Mr. Mantha and advocate, Mr. Mantha pays for advocacy to have a lesson instructor. In view thereof, matter stand adjourned is the matter for further.
Well, is it kindly give me liberty to take those photographs and bring that by way of an affidavit? The other side. I'll do that. I'll bring that on that. I'll bring that on the
Mr. Mantha pays for a link to bring
Recent photo
a recent photograph of the
premises.
Premises.
And to end before
To
this,
advise the court of the state within state of affairs of that local. Local will only do
state of affairs.
state of affairs in and around the premises, around the premises. So in there are the stand action is the matter of the consideration of cases. Sadly, this can
kindly at a certain time because it's a matter of encroachment and ingress egress.
So the ingress is good for it, because I do not stand in the way in fixing the way. That kind of prerogative.
Enjoy.
Photographs bullets. You will learn. The desire of the court is to see whether the problem is to be settled. If I am the advocate and if somebody says my client is abusing, you have no other option but simply I do not have any instruction. You can say that. We also understand the practical aspects of it. But we are living in a civilized society. Suppose I come to court and my relatives face backbiting, that you don't understand what sort of abuses are used. And nowadays people has listened to us. Nowadays people has got to that extent that they publish that vulgar language on the wall of the building. That even if somebody stares at it, you will be finding what sort of a society we are living in.
It's unfortunate, situation, we are all victim of.
You are not victim. You are trying not to accept not acceptance. You could have kept quiet because this is a normal sequence. You could have kept quiet. You are quite senior now. Your first duty is to the court, not to your clients. You are our officers.
Yes, but
So if a statement is made that Mr. Karmakar, ask your clients not to use any abusive language, you are saying that no, they are not using that. You have no other option to say that.
exactly that's what I said. If such thing is being done, I will
Now,
definitely
if
make sure it's not happening.
the conversation of the advocate with the client is that sort that continue to make abuses, I will say in court that no, I don't have any instruction. Then problems can never be solved. We understand your problems also, but after all, we are in a society.
But, I do not understand, but I fail to express that my clients I do not know this aspersion on my client from the bar. I do not know the veracity of it. I have not.
That is exactly what we are
Don't try
saying.
to defend if it is happened.
That if this kind of thing has happened, I will make sure.
Yes.
That is what exactly. That ought to have been your subject.
That's exactly what I said.
Sorry, you said that I don't know what is happening. I have to take instruction.
That was my.
Anyway,
Mr. Karmakar, we cannot encourage. A footpath is not only for the use of the person just adjacent to the house stand.
But I showed
A
you.
footpath can be used to all people. Anyone can use. It is not for the inhabitants of that particular
I
locality.
reside in Happy who better knows than me what is footpath
And it is being used for the purpose of, for the benefit of 2 or 3 or 7, 8, 9%.
I reside in Happy who better can see than me what happens at footpath.
in Godiat, what happens?
Exactly.
In Godiat, they put in that fire broke out to start being uses of plastic material. Plastic. So when that fire broke out, livelihood of the people is also involved. So how do they run their business? They take the total stock and put it inside that Baliganj New Market where there are space in the godown. In the morning, they come and bring out that stock and display it in the footpath. Now, once it so happened, fire broke out. KMC was under an obligation to take approval. Pressure comes, KMC goes, removes every. You go there after 15 days, again those covers.
While going to my house back, regularly.
All right, come back. What do you think is the 30th?
This is not a party.
Yes.
That has been settled before this code. In the previous week.
Take it up.
Let us fix the matter. The question is.
But take that instruction.
I will. Since there's fallen from my lord and the lordship.
You also talk with him.
I will. That's my.
You see, if the court desires the problem to be solved,
Absolutely. Something can be done and then nothing.
then nothing.
Well, as we kindly fix it at some point. Sometime.
No, it will be taken up. You have kept on 30th.
Not since order.
But it is coming for the first time.
17 they have received.
Very good. Come and tell us tomorrow. Yes.